welcome to Requiro. Today we are going to be talking about Luigi Mangione. Yay! I know that's like the only video you guys mostly care about on this channel. So I'm going to be talking about the most recent updates on the Luigi Mangione case since my last video on Luigi Mangione, and that was the 57-page pre-trial motion by Karen Agafillo for his case, and that was a big video. And that was about a month ago. I'm going to be talking about the most recent updates since that video. I've made a couple of these videos in the past where I've talked about the updates on the Luigi Mangione case, and this is just another one of those videos of gathering all the information over the last month or so of updates on what's going on with his case. I do want to say this here, I was originally planning to do this update on Luigi Mangione when he was meant to appear in court this week as filming this video. So he was meant to appear in court on June 26, but that was delayed and cancelled for some reason, and his new court appearance will be in September of this year. But I was originally planning to cover the court appearance when he showed up, but that was cancelled and delayed, and I think we'll find out more about that, like why it was cancelled and delayed later on in the future. It was discussed briefly, but we'll get to that point later on when we get to that point in the video. Thought I should make this video anyway, so to give you guys updates on Luigi Mangione. And I know it's been a bit quiet at the moment on Luigi Mangione's case just because he's not showed up in court or anything like that, but there have been things going on his case. It's just been like quiet and pieces popping up time to time. So that's why this video's here, because I want to keep making videos like this where I have all the facts straight and I can make these videos and all the accurate information on Luigi Mangione is all in one place instead of it getting lost on the sea of the internet, and all the updates and information on Luigi Mangione is not just strictly through the media that's already biased towards him. One thing I keep saying one thing when I add 5 more things when I say that, but I do want to add this here is, so I know I mentioned in my last video talking about Luigi Mangione where I said it would be interesting to see where if the police uploaded and released to the public the alleged manifesto and we could like compare it to his original handwriting from the letters. And literally in that week when I uploaded that video, that actually happened, and I will talk about that briefly in the video, and why they released it is very interesting. And I did talk about that briefly on like Reddit, where comparing his handwriting from his actual letters we've seen from him and the actual manifesto, and then like people just yelled at me on Reddit saying I'm wrong. So I took the post down. It's like, why is everyone yelling at me here? So saying that here is, I'm not going to be talking about the alleged manifesto because I can't find actual like legit sources saying yes, this is from the police and all that. Maybe it is. Hi, it's Voice on Me. I feel like I need to add more context to that, to what I said before. So I legitimately could not find where the actual picture of the alleged manifesto the police released that they allegedly found in Luigi Mangione's backpack. I legitimately could not find the legit source of where that came from, and I do really want to like find actual accurate sources of information for you guys when I make these type of videos. And I don't know why. I think it's because literally where I live in the part of the world, but I know every like news network and basically people on Reddit ran with that. So I don't know what it is. Maybe it's like my part of the world, I don't get the official sources or anything. Like I generally did look for it and I could not find any official sources. Like the only places I could find the alleged manifesto photos released were like on Reddit. And I know that sounds a little bit hypocritical of me because I have done in this video in the past where I get actual official documents from Reddit for cases like this, but when I do that I always double check the documents and make sure they actually are real, and I also know they have the actual link in the actual Reddit post, but I just don't have access because I don't live in the United States. So I just thought I should put that here and clear that up. But again, I will talk about that briefly later on in the video. And like I mentioned in my last video, Luigi Mangione's backpack was searched multiple times without a search warrant, and 7 hours later, they got a search warrant on Luigi Mangione's backpack, and again, his backpack was already searched multiple times, and anything could have happened in those 7 hours for those things to appear or being done. So please keep that in mind. I kind of have that in the back of my mind. Also, I discovered this when I was on Reddit. Someone actually uploaded the link to the actual Prosecutors side where they upload all their documents, so I'm so glad they did. So I've saved that website for Prosecutors on Luigi Mangione's case. I'll put it up in the description down below. It'll also be on the website as well, but I'm glad I finally have that website, so now I can see the documents more so in person on my side of the world instead of just relying on Reddit for that kind of thing of what the hell's going on with Luigi Mangione's case. So if there's anything I got wrong or I missed or anything like that, because again, I am one person on this channel working on this, I will get things wrong and I will make mistakes. Please let me know if I make any mistakes or anything like that. Put it in the description down below, and I'll sure to pin it down below or bring it up in my next video. So, and also all the sources and everything I used in this video will be up on the website on this week's episode, so you guys can go check out the sources yourselves and all that. Also, this I just kind of find it funny now, so when I post shorts, because I kind of have to, because that's how the internet is now, where I have to post shorts like TikTok and Instagram and YouTube, etc. So I do find it funny. I mostly see it here on YouTube, where when I post shorts about talking about little bits of facts, what's happening on the case, and then I just get comments of people calling me crazy about talking about facts happening with the case. Yeah, I just think that's funny. So yeah, I'm not crazy about talking about facts on the Luigi Mangione case. Maybe it's because I'm a girl and I dress up. Maybe that's why they call me delusional. I don't appreciate that, by the way. I'm not Delulu for Lulu. Is that the shortening for Luigi or something? I heard that somewhere. It was fucking hilarious. Give me a minute, I'm looking it up. Yeah, that is a nickname for someone called Luigi, so it's Lu. So yeah, anyway, there's a lot of funny nicknames for someone called Luigi. I just went on the subreddit and it's actually quite funny. I recommend go check it out. If you have a friend called Luigi, you can give him some fun nicknames. You stop joking around. I said Lulu and now I'm flustered. We're moving on from me just finding the nickname for Lulu. Now, let's get into the video. The 9th of May 2025. So this is more so on the prosecutor's side, where they've ordered the motion to continue for filing. Basically that's what it is. It's been filed, and I won't read the full thing. Again, we've read it before in the past, and I'll just put up the thing that is most relevant for you guys. So I'll put it up on screen for you guys.
The 5th of September 2025, the 5th of May 2025, Bernard, Jackie Atherton order granting motion for continuance, Blair County District Attorney's Office, the 5th of September 2025, e-service served, Dickey, Thomas M. the 5th of September 2025, e-service served.
The 16th of May 2025. This is also filed by the prosecution. They are requesting a protective order, and there are 2 documents on this date. So one is a letter and one is a proposed protective order. So I'll put up the letter on screen first.
U.S. Department of Justice, United States Attorney, Southern District of New York, Jacob K. Javits, Federal Building 26, Federal Plaza, 37th floor, New York, New York, 10278. May 16, 2025. Via ECF Honorable Margaret M. Garnett, United States District Judge, Southern District of New York, 40 Foley Square, New York, New York, 10007. Re. United States vs. Luigi Nicholas Mangione, 25 CR 176, MMG. Dear Judge Garnett, attached for the court's review and consideration is a proposed protective order in the above captioned matter. The parties have agreed to the terms of the protective order, which provide for the government to produce materials under specific designations and allow the defendant to contest those designations before the court. Respectfully submitted, Amanda L. Howell, attorney for the United States Attorney acting under authority conferred by 28 U.S.C. Section 515. United States District Court, Southern District of New York, United States of America versus Luigi Nicolas Mangione, defendant. Protective Order 25 CR 176, MMG, upon the application of the United States of America, with the consent of the undersigned counsel, and the defendant having requested discovery under Fed. Acrim. P16, the court hereby finds and orders as follows. Categories 1. Disclosure material. The government will make disclosure to the defendant of documents, objects, and information, including electronically stored information, EC, pursuant to Federal Rule of Criminal Procedure 16, 18 U.S.C. Section 3500, and the government's general obligation to produce exculpatory and impeachment material in criminal cases, all of which will be referred to herein as disclosure material. The government's disclosure material may include material that I. affects the privacy, confidentiality and business interests of individuals and entities. 2. Would risk prejudicial pre-trial publicity if publicly disseminated. 3. May be produced with more limited redactions than would otherwise be necessary. And 5. That is not authorized to be disclosed to the public or disclosed beyond that which is necessary for the defense of this criminal case. 2. Attorney's possession only. APO. Material. Certain materials in this case raise a particular risk of affecting the privacy or safety of victims or witnesses, or the confidentiality of ongoing investigations. Disclosure material produced by the government to the defendant or his counsel that is either 1. Designated in whole or in part as attorney's possession only by the government in emails or communications to defense counsel, or 2. That includes abates or other label stating attorney's possession only or APO shall be deemed APO material. 3. Attorney's eyes only, AEO, material. Certain materials in this case raise a more significant risk of affecting the privacy or safety of victims or witnesses, or the confidentiality of ongoing investigations. Disclosure material produced by the government to the defendant or his counsel that is either 1. Designated in whole or in part as attorney's eyes only by the government in emails or communications to defense counsel, or 2. That includes abates or other labels stating attorney's eyes only or AEO shall be deemed AEO material. Now, therefore, for good cause shown, ITIS hereby ordered, disclosure and treatment. 4. Disclosure material shall not be disclosed by the defendant or defense counsel, including any successor counsel, the defense, other than as set forth herein, and shall be used by the defense solely for purposes of defending this action. The defense shall not post any disclosure material on any internet site or network site, including any social media site, to which persons other than the parties hereto have access, and shall not disclose any disclosure material to the media. 5. APO material received by defense counsel shall be maintained in a safe and secure manner by defense counsel, and any personnel for whose conduct defense counsel is responsible shall not be possessed by the defendant, except in the presence of the defendant's counsel, and any personnel for whose conduct defense counsel is responsible, and shall not be disclosed in any form by the defendant, his counsel, or any personnel for whose conduct defense counsel is responsible, except as set forth herein. APO material pertinent to any motion before the court should initially be filed under seal, absent consent of the government or order of the court. 6. AEO material received by defense counsel shall be maintained on an attorney's eyes only basis, and the defense shall not share any AEO material or the content of the AEO material with any other persons, including the defendant, except for any personnel for whose conduct defense counsel is responsible. AEO material pertinent to any motion before the court should initially be filed under seal, absent consent of the government or order of the court. Other provisions. 7. This order does not prevent the disclosure of any disclosure material in any hearing or trial held in this action, or to any judge or magistrate judge, for purposes of this action, but, except to the extent provided otherwise below, shall not be disclosed or used in any form in any other civil litigation, arbitration, or other private or alternative dispute resolution. All filings should comply with the privacy protection provisions of Fed. Acrim. P 49.1 and the above provisions. 8. The government's designation of material will be controlling absent contrary order of the court. The parties shall meet and confer regarding any dispute over such designations, after which the defense may seek a designation by the court. The government may authorize, in writing, disclosure of disclosure material beyond that otherwise permitted by this order without further order of this court. 9. The defense shall provide a copy of this order to prospective witnesses and persons retained by counsel to whom the defense has disclosed disclosure material. All such persons shall be subject to the terms of this order. Defense counsel shall maintain a record of what information has been disclosed to which such persons. N. Except for disclosure material that has been made part of the record of this case, the defense shall return to the government or securely destroy or delete all disclosure material, including any ESI, within 30 days of the expiration of the period for direct appeal from any verdict in the above captioned case, the period of direct appeal from any order dismissing any of the charges in the above captioned case, and the granting of any motion made on behalf of the government dismissing any charges in the above captioned case, whichever date is later, subject to defense counsel's obligation to retain client files under the rules of professional conduct. If disclosure material is provided to any personnel for whose conduct defense counsel is responsible or prospective witnesses, defense counsel shall make reasonable efforts to seek the return or destruction of such materials. Of jurisdiction. 11. The provisions of this order shall not terminate at the conclusion of this criminal prosecution, and the court will retain jurisdiction to enforce this order following termination of the case.
So it is very interesting why they want a protection order put in place, like so far in. Like I remember it was briefly mentioned at the beginning when this all started, but again, we talked about this before in the past, where basically it was the police who put in fear from the United Healthcare people of what's going to happen to them, of what happened to the CEO. That was just basically them explaining why they want the protection order. I've already said this before, like, it was very much the police who put that fear and stuff into the actual healthcare workers who worked for the United Healthcare, and also, like, other healthcare system in America. So it was very much the police, not Luigi himself, if that makes sense. Like, I find it interesting, it's like, why are they enacting it now? Like, in this point in the document, it is like 5 months at that point. Like, why are they enacting it now compared to like at the beginning? May 19th, 2025. This is also filed by the prosecutor side. So basically this is just an update of the document we just looked at of what is being granted or not for the protective order. So I'll put up on screen for you guys.
United States District Court, Southern District of New York, United States of America versus Luigi Nicolas Mangione, defendant. Protective Order 25 CR 176, MMG, upon the application of the United States of America, with the consent of the undersigned counsel, and the defendant having requested discovery under Fed. Acrim. P16, the court hereby finds and orders as follows. Categories 1. Disclosure material. The government will make disclosure to the defendant of documents, objects, and information, including electronically stored information, EC, pursuant to Federal Rule of Criminal Procedure 16, 18 U.S.C. Section 3500, and the government's general obligation to produce exculpatory and impeachment material in criminal cases, all of which will be referred to herein as disclosure material. The government's disclosure material may include material that I. affects the privacy, confidentiality and business interests of individuals and entities. 2. Would risk prejudicial pre-trial publicity if publicly disseminated. 3. May be produced with more limited redactions than would otherwise be necessary. And 5. That is not authorized to be disclosed to the public or disclosed beyond that which is necessary for the defense of this criminal case. 2. Attorney's possession only. APO. Material. Certain materials in this case raise a particular risk of affecting the privacy or safety of victims or witnesses, or the confidentiality of ongoing investigations. Disclosure material produced by the government to the defendant or his counsel that is either 1. designated in whole or in part as attorney's possession only by the government in emails or communications to defense counsel, or 2. That includes abates or other labels stating attorney's possession only or APO shall be deemed APO material. 3. Attorney's eyes only, AEO, material. Certain materials in this case raise a more significant risk of affecting the privacy or safety of victims or witnesses, or the confidentiality of ongoing investigations. Disclosure material produced by the government to the defendant or his counsel that is either 1. Designated in whole or in part as attorney's eyes only by the government in emails or communications to defense counsel, or 2. That includes abates or other labels stating attorney's eyes only or AEO shall be deemed AEO material. Now, therefore, the good cause shown, ITIS hereby ordered, disclosure and treatment for disclosure material shall not be disclosed by the defendant or defense counsel, including any successor counsel, the defense, other than as set forth herein, and shall be used by the defense solely for purposes of defending this action. The defense shall not post any disclosure material on any internet site or network site, including any social media site, to which persons other than the parties hereto have access, and shall not disclose any disclosure material to the media. 5. APO material received by defense counsel shall be maintained in a safe and secure manner by defense counsel, and any personnel for whose conduct defense counsel is responsible shall not be possessed by the defendant, except in the presence of the defendant's counsel, and any personnel for whose conduct defense counsel is responsible, and shall not be disclosed in any form by the defendant, his counsel, or any personnel for whose conduct defense counsel is responsible, except as set forth herein. APO material pertinent to any motion before the court should initially be filed under seal, absent consent of the government or order of the court. 6. AEO material received by defense counsel shall be maintained on an attorney's eyes only basis, and the defense shall not share any AEO material or the content of the AEO material with any other persons, including the defendant, except for any personnel for whose conduct defense counsel is responsible. AEO material pertinent to any motion before the court should initially be filed under seal, absent consent of the government or order of the court. Other provisions. 7. This order does not prevent the disclosure of any disclosure material in any hearing or trial held in this action, or to any judge or magistrate judge, for purposes of this action, but, except to the extent provided otherwise below, shall not be disclosed or used in any form in any other civil litigation, arbitration, or other private or alternative dispute resolution. All filings should comply with the privacy protection provisions of Fed. ACRIM, P 49.1 and the above provisions. 8. The government's designation of material will be controlling absent contrary order of the court. The parties shall meet and confer regarding any dispute over such designations, after which the defense may seek a designation by the court. The government may authorize, in writing, disclosure of disclosure material beyond that otherwise permitted by this order without further order of this court. 9. The defense shall provide a copy of this order to prospective witnesses and persons retained by counsel to whom the defense has disclosed disclosure material. All such persons shall be subject to the terms of this order. Defense counsel shall maintain a record of what information has been disclosed to which such persons. 10. Except for disclosure material that has been made part of the record of this case, the defense shall return to the government or securely destroy or delete all disclosure material, including any ESI, within 30 days of the expiration of the period for direct appeal from any verdict in the above captioned case, the period of direct appeal from any order dismissing any of the charges in the above captioned case, and the granting of any motion made on behalf of the government dismissing any charges in the above captioned case, whichever date is later, subject to defense counsel's obligation to retain client files under the rules of professional conduct. If disclosure material is provided to any personnel for whose conduct defense counsel is responsible or prospective witnesses, defense counsel shall make reasonable efforts to seek the return or destruction of such materials. Retention of jurisdiction. 11. The provisions of this order shall not terminate at the conclusion of this criminal prosecution, and the court will retain jurisdiction to enforce this order following termination of the case.
the 25th of May 2025. So this is less about like facts of documents in the case, but I just thought this would be useful anyway, where this is basically an article talking about the misconduct in Luigi Mangione's case. They pointed at like 4 things. I read the actual article itself, and yeah, there are things right there, but like, you can check out the article if you want to, but a lot of the things I saw in there was literally all the things I was saying in my past videos on Luigi Mangione. So go check those videos out if you don't want to read the article, but you can read the article if you want. But I just thought that was interesting to bring up here anyway, because not a lot of people are talking about that, unless they're in the subreddit or you're me making these videos. Or unless you're like Status Quo News. I recommend check those guys out. They do really good coverage on like Luigi Mangione case and also what's going on in the United States, and they actually give out the facts, right, about what's actually going on with his case compared to the bias that the news media is putting on Luigi Mangione. So I recommend to go check those guys out. I mentioned them in my first video, but I am going to mention them here now. And if you guys don't want to go check out their channel, I have a full playlist of their videos strictly on Luigi Mangione on this channel, so you can go check it out from Status Quo News. The 3rd of June 2025, so this is when it was officially updated on Luigi Mangione's legal website, where the dates have been changed for Luigi Mangione to show up in court. This is when it was officially updated and changed for it to be changed for September, instead of it happening on June 26th when it was meant to happen. But yeah, this was like when it was first officially announced, and it was very interesting, honestly, the discussion around it. Again, we'll go with that in a little bit more detail in the next couple of documents. So this also came out on the same day as the change date from Luigi Mangione's official court date. This is a motion from Luigi Mangione's legal team. It was very nice to hear because we haven't heard any updates from his actual legal team in a while, so it was very nice to hear and see that how big the actual document is. So I'll put it up on screen for you guys.
June 3rd, 2025. Supreme Court of the State of New York, 100 Center Street, Part 32, New York. New York 10013. Re. People vs. Luigi Mangione. Bind. Number 75657 per 2024. Dear Judge Caro, June 3rd, 2025, we respectfully request that during the next court appearance on June 26th, 202, Mr. Mangione be permitted to have his hands unshackled while seated at the defense table, and he be permitted to wear court-appropriate clothing without a bulletproof vest. The authorities, both state and federal, have already prejudiced Mr. Mangione in the media more than virtually any defendant in recent memory. This commenced with the NYC Mayor-led staged perp walk, and it continues until today. These same authorities should not use Your Honor's courtroom and Mr. Mangione's court appearances to perpetuate a false narrative that Mr. Mangione is an unusual danger requiring extraordinary security measures. There is no disputing that he has been a model prisoner, a model defendant in court, and has treated everyone in the court and prison system with cooperation and respect. These deeply prejudicial security measures, which are invariably photographed and circulated to the public, including potential jurors, are unnecessary and should not continue as they are damaging to Mr. Mangione's right to a fair trial. A narrowly tailored request, which is in the court's discretion, is that Your Honor permit Mr. Mangione, when seated at counsel table, to be treated like other defendants and have his arms unshackled and no bulletproof vest, which is how he appeared in federal court in December 2024 and April 2025, without the need for counsel to request these conditions. One, wearing handcuffs and a visible bulletproof vest in court unfairly prejudices Mr. Mangione and impedes his right to effectively defend himself for no justifiable reason. Notably, when counsel made a request to unshackle Mr. Mangione at February 21st, 2025, court appearance, this court initially responded, "Go ahead and uncuff him." 2/21, 25 TR at 2. After a court officer approached the bench and had an off-the-record conversation with the court without counsel present, Your Honor stated, for security reasons, they want him cuffed ID. Without elaborating what the security issues were, the court then allowed counsel to make the following record, T. His is a highly publicized and covered and photographed court proceeding with strong public interest, and when my client comes to court, because he's in Federal 1 to provide a reasonable compromise, we are not requesting that his legs be unshackled for the court appearance. This in no way, however, indicates that we believe there is a need for his legs to be shackled, as we do not believe him to be a flight or safety risk. Honorable Gregory Caro, June 3, 2025 custody. They bring him, they walk him in leg shackles, arm shackles. They have him sitting here, and there is no presumption of innocence. I'd also like to let you know that I go visit him regularly at MDC, where we sit in a room. He's completely unshackled. He is a model prisoner at MDC. There has not been an issue. He has not given the police one single problem. There is no reason for him to be this way in court with all these officers here standing here. JD at 3. In response, the court noted as follows: I understand that, but for security reasons and for the security people here, they would prefer him to remain cuffed. ID. Courts have long recognized that visibly shackling a defendant in front of a jury is prejudicial, and thus, they should not be physically restrained unless it is justified by a special need specific to the defendant, such as the defendant's behavior or risk of escape, neither of which are present in this case. In Deck versus Missouri, the Supreme Court noted that the law has long forbidden routine use of visible shackles during the guilt phase. Deck versus Missouri, 544 U.S. 622, 626, 2005. Rather, the Constitution requires that a defendant can only be shackled in the presence of a special need, ID. The Supreme Court stated 3 reasons for its decision. First, the criminal process presumes that the defendant is innocent until proven guilty, ID. At 630. This bedrock of criminal justice is undermined by shackling because it suggests to the jury that the justice system itself sees a need to separate a defendant from the community at large, ID. Quotations omitted. Second, shackling a defendant can interfere with the accused's ability to communicate with his lawyer and his ability to participate in his own defense, both rights guaranteed by the Constitution, ID. Third, judges must seek to maintain a judicial process that is a dignified process. As the court noted, the courtroom's formal dignity, which includes the respectful treatment of defendants, reflects the importance of the matter at issue, guilt or innocence, and the gravity with which Americans consider any deprivation of an individual's liberty through criminal punishment, and it reflects a seriousness of purpose that helps to explain the judicial system's power to inspire the confidence and to affect the behavior of a general public whose demands for justice our courts seek to serve. The routine use of shackles in the presence of juries would undermine these symbolic yet concrete objectives. ID. At 631. For these 3 reasons, the court ruled that due process does not permit the use of visible restraints if the trial court has not taken account of the circumstances of the particular case. ID. At 632. Consistent with Deck, the New York Court of Appeals has held that, as a matter of both federal and state constitutional law, a trial defendant has the right to be free of visible shackles, unless there has been a case specific, on the record finding of necessity. People v. Best, 19 NY, 3D 742, 743, 2012. See also People v. Sanders, 39 NY, 3D 216220, 2023. The Due Process Clause of the 14th Amendment to the United States Constitution prohibits states from physically restraining a defendant during a criminal trial without an on-the-record, individualized assessment of the state interest specific to a particular trial. Quoting Deck, as part of its decision, the Court of Appeals noted that it could not ignore the way the image of a handcuffed or shackled defendant affects the public's perception of that person and of criminal proceedings generally. Best, 19 NY, 3D at 744. In doing so, New York's highest court in Best extended Deck to consider the effect that shackles will have on the public's perception of a defendant, exactly the concern that Mr. Mangione is voicing in this motion. Although Deck and Best refer to cases in trial and sentencing postures, the rationale underlying these decisions equally applies in Mr. Mangione's case given the high-profile nature of the 3 concurrent prosecutions. While there is obviously no jury in the courtroom for the prejudicial restraining of Mr. Mangione, because of the unprecedented public interest in these cases, DEC and BEST still apply. Every court appearance is widely covered by the news and social media, providing video footage, still images, court sketches, online content and multiple purported documentaries where actors attempt to recreate every alleged aspect of this case. In fact, after February 21, 2025, court appearance, images of Mr. Mangione in handcuffs and a bulletproof vest were featured in major news organizations such as Reuters, The Washington Post, The New York Times, The New York Daily News, The New York Post, BBC and NBC, as well on social media platforms such as X and Reddit, to name only a few. These news and social media articles attract millions of views. For example, one photograph of Mr. Mangone's shackled ankles while seated in this court was posted on X and has garnered more than 36 million views. Consequently, given that Mr. Mangione will be photographed and sketched at the next appearance in court and potentially video recorded, 2. The repeated imagery of Mr. Mangione in shackles with a bulletproof vest unjustifiably prejudices Mr. Mangione in the eyes of future jurors by portraying him as a dangerous person who requires special security treatment in court. In addition to pre-trial prejudice concerns, shackling Mr. Mangone's hands will limit his ability to meaningfully participate in his defense by preventing him from accessing his legal papers, taking notes and providing notes to counsel during the appearance. Such interference with a defendant's ability to communicate with his lawyer was part of the Supreme Court's analysis in DEC and applies equally in Mr. Mangone's case. Furthermore, there is no reasonable security justification to physically restrain Mr. Mangione differently in state court than in federal court. Since Mr. Mangione was first arrested in Altoona, Pennsylvania, he has been respectful and cooperative and has not been either a flight or security risk, as has been widely reported and is captured on multiple police body-worn camera videos. At the time of Mr. Mangone's arrest, he was calm and compliant and did not attempt to flee or disobey the police officer's instructions in any way. Not only was he respectful with law enforcement, but his first reaction while being arrested was to express concern for the safety of the McDonald's worker who called the police, again demonstrating his sympathy for others and lack of a need for heightened security measures. Since most of Mr. Mangone's actions were captured on law enforcement cameras the day of his arrest, the court can independently verify this information too. Mr. Mangone's initial arraignment was broadcast via video. Only still camera photos were present for his subsequent court appearance. For the sake of transparency and the media's and public's First Amendment rights, Mr. Mangione consents to future court appearances being both photographed and broadcast via video. By all accounts, Mr. Mangone's cooperative and compliant behavior continued throughout his 10 days while in custody in the Commonwealth of Pennsylvania. On December 19, 2024, Mr. Mangione was transported without incident from Pennsylvania to New York, after waiving extradition. Again, most of this transportation via a 15-car police caravan, an airplane, and a helicopter was captured on video, including the now infamous perp walk where authorities staged Mr. Mangione surrounded by heavily armed police officers with automatic rifles visibly on display and at the ready. As a result, Mr. Mangone's actions demonstrating cooperation and compliance have been documented in great detail, from multiple angles and multiple cameras, and have been widely viewed around the world. Counsel has now viewed hundreds of hours of said video recordings, and there is not a single instance where Mr. Mangione is disruptive, uncooperative, disobedient or non-compliant. Mr. Mangione has been held in federal custody at the Metropolitan Detention Center, MDC, located in Brooklyn, New York, since December 19, 2024. During the 167 days in pretrial detention, Mr. Mangione has not been a security or flight risk requiring special, restricted or different treatment than any other general MDC inmate. He has never been cited by officers for misconduct, nor has he ever been punished or restricted. He has not exhibited any uncooperative behavior and has not been placed in any specially restricted location, such as the Special Housing Unit, also known as the SHU. In fact, he has been assigned to a work detail and is in the general population. To further illustrate this point, counsel visits Mr. Mangione nearly daily in the common visitor area at the MDC, a large open room with rows of small plastic chairs and no barriers between people or groups. where unshackled inmates meet with their families, and where visitors and lawyers walk freely to buy food from vending machines and heat their food in a microwave. There are often dozens of people, including young children, babies, family members and others, sitting arms length apart in the same large area as a completely unshackled Mr. Mangione. In other words, Mr. Mangione is treated just like any other pre-trial detainee, not like someone who is a heightened security or flight risk. There is also no security justification for requiring Mr. Mangione to wear a bulletproof vest in a courthouse where all visitors are screened through a metal detector on arrival. Tellingly, Mr. Mangione was not required to wear a bulletproof vest at his December 23, 2024, Arraignment 3, the single instance where Mr. Mangione's behavior could be misinterpreted as anything other than cooperative occurred outside the Pennsylvania courthouse on December 10, 2024, when he turned to the press to state, "Your coverage of this event is completely out of touch and an insult to the intelligence of the American people and their lived experience." Footage of this interaction has been widely viewed and repeatedly broadcast, typically as a partial clip or with audio strategically removed to portray Mr. Mangione as erratic. A careful look at this footage, however, clearly shows Mr. Mangione's calm demeanor both as he exits the police car and after he walks through the courthouse door. The only physical aggression is exercised by the multiple officers who physically slam him against the wall to silence him once he begins speaking. At no point in this clip does Mr. Mangione resist at all before this court, and there is no reason for him to be wearing one now. To counsel's knowledge, there have been no threats to Mr. Mangione's safety, and the only one wishing to execute him is the federal government. Wearing a bulletproof vest therefore serves no other purpose than to prejudice Mr. Mangione in the media and before future potential jurors. Each time Mr. Mangione has appeared in federal court both in December 2024 and more recently in April 2025, he was wearing neither a bulletproof vest nor arm restraints of any sort, only leg shackles, which is what we are requesting here. Notably, counsel did not even have to request that Mr. Mangione appear with his hands unrestrained, as the U.S. Marshals Service removed his restraints on their own as is standard. There is no justification to treat Mr. Mangione's security protocol differently in state court than in the more serious federal court case where he faces potential execution. That Mr. Mangione's state court appearances have cameras in the courtroom, as opposed to federal court, does not suddenly turn Mr. Mangione into more of a security threat that requires shackles and a bulletproof vest in the courtroom, especially given that the state and federal cases involve identical allegations. To conclude, Mr. Mangione respectfully requests that he be permitted to sit in the courtroom without shackles on his hands and without wearing a bulletproof vest. Since the inception of this case, Mr. Mangione has been strategically portrayed to require heightened security measures and has endured unnecessary and prejudicial militaristic shows of force. Nevertheless, the holdings in Deccan best inform Mr. Mangione's request today, as the photographs circulated of Mr. Mangione in Your Honour's courtroom are prejudicing future jurors against him, including some who may weigh the application of the death penalty to his federal case. Mr. Mangione is not a security threat. Since his arrest, he has been and remains cooperative, compliant and entirely non-violent. This has been the case in state court, federal court, Pennsylvania, and while detained at the MDC, where he interacts nearly every day without physical restraints with attorneys, other prisoners and visitors in a large visiting room. Accordingly, there is no reason why the same security measures that apply in federal court should not apply in state court as well. Moreover, Mr. Mangione should also be allowed to wear court-appropriate civilian clothing during his court appearances, for by allowing Mr. Mangione to appear with his hands unshackled, without a bulletproof vest, and wearing normal clothes, this court will reinforce Mr. Mangione's presumption of innocence and limit the pre-trial prejudice that Mr. Mangione faces, given that images from the court appearance will undoubtedly be viewed millions of times and by potential jurors. While the District Attorney's Office has previously accommodated counsel requests that Mr. Mangione be allowed to wear civilian clothing at his court appearances, we are seeking a court order to ensure that these accommodations continue throughout the pendency of this case.
So basically here, Karen Acafillo is requesting for Luigi Mangione not to be shackled and chained and be allowed to wear court approval clothing and also not be in a vest, like we've seen in his last couple appearances where there's cameras. And I found it very interesting and very nice for her to put this here, because it is not fair on Luigi Mangione to be shackled and all that, because police and the court and people are just trying to paint him as bad as a person as possible. Like, oh, look at this big, dangerous, scary man. We have to do this for our own protection. But in reality, he's not. And I mentioned this before in my last couple of videos. So they very much just chained him up, put him in a vest, literally just for cameras. Last time we heard Luigi Mangione was in court, there was no cameras, there was only sketches, and he was very much not chained up. He was in a, I think, summer prison uniform, and he was very much not chained up whatsoever compared to when there were cameras in the room. So I found it very nice Karen Acafillo mentioned this and put it here, so hopefully in Luigi Mangione's next court appearance he won't be shackled, he won't be in chains, he won't be wearing a vest, and he will be in court approval clothing. This I found very interesting when I was reading this document. Things that were mentioned back in like February when Karen made a statement to the press about Luigi Mangione when he was very much first shackled and seen in a vest. Those things that were mentioned back then was also mentioned in this document as well, and I think those words she said back then are still very much relevant to today as well with Luigi Mangione's case as well. I just found that interesting. And when Luigi Mangione had his second court appearance, it was very alarming to see where he was put in a vest and was shackled. His ankles were shackled, and then his ankles went viral on the internet because loafers with no socks. I don't get it. This I found actually funny. When I was reading the document, Karen did mention Luigi Mangione's ankles were circling around on the internet and they went viral. I thought that was funny, and that was written in the document. The answer is yeah, they did. People lost their minds. Everyone loves Luigi Mangione's ankles. Also, this was also brought up in the document because Karen Acafillo knows, because of the high profile of this case and how much people actually love him or hate him or both, and also how much people think how cute he is. The photos of Luigi will go viral no matter what. So because of this reason, Karen says Luigi Mangione deserves to look his best for those reasons, because no matter what, the photos will go viral and he deserves to look his best and look appropriate for the court appearances he will be in. And it also will give the jury a fair idea of Luigi Mangione, because again, it's mentioned in a couple of other documents and also this one as well, where the people shown being put in shackled makes the jury have a certain mindset of the actual person's character, even if they don't know him, even if they're in shackles, compared to when they're not in shackles. There's actually a lore about it. I saw it somewhere in the documents. I read so much yesterday on this. Okay, so this bit isn't important, but I just thought it was interesting. So when they were taking Luigi Mangione from Pennsylvania to New York, there were so much transportation he had to go through. He was in a police car, he was in a police van, he was in a helicopter just to get to New York. It's oh my god, so much transportation. That's not important. I just wanted to mention it because it was in the document. I didn't realize there was so much transportation to transfer Luigi from Pennsylvania to New York. Basically, the reason why the police say, oh, we're keeping him shackled and detained like this when he's in court is for our safety, and literally the only time Luigi showed any aggression or anything like that was when he had his first court hearing in Pennsylvania, where he yelled at the press about reporting this case, and then he was shoved against the wall by police and then pushed into the actual courthouse. Any time before then and then after that, he calmly walked out of the car when he was going into the courtroom, and then he also very much quietly walked in, and then same thing afterwards as well. He'd just peacefully walked into the cop car afterwards. And also in prison, Luigi Mangione is very much being shown as a moderate prisoner, not shown any violence whatsoever, so there would be no reason for Luigi Mangione to be shackled and chained like he has been put in. And also, like, when Luigi Mangione was like shoved against the wall, there was rumors going around, there was bruises on his neck afterwards. Again, I don't know if that's true or not, but I kind of feel like they might be, because, you know, being shoved against the wall is not the lightest thing in the world. So I love this bit. This is mentioned in the document. So basically, I love this bit. So basically, Karen says there is no reason for Luigi to wear a bulletproof vest because there is no danger towards Luigi Mangione's life, and the only people that are trying to kill him is the prosecutors and the government. I love that bit. Oh god. I love your responses, Karen. Anyway, I love that bit. I love Karen's responses. They're so good. So basically, at the end of the document, wrapping everything up, basically says Luigi Mangione is requesting to be not shackled in his court appearances, not to have a vest put on him, and also be able to wear court approval clothing like he deserves, because he has been a moderate prisoner in and out of prison. It just says that, in and out of prison, so I'm assuming like going to the court appearances. I think that's what they mean, instead of like him being out and about. I think we would know about that if he was. So he should be allowed to not be shackled and wear court approval clothing. So I hope in his next court appearances we will see that he will be not shackled and chained and in a vest like we've seen in the past. The 15th of June 2025, this is the defense requesting a extension from the death penalty motions. I'll put it up on screen for you guys.
ECF Hon, Margaret M. Garnett, U.S. District Judge, U.S. Courthouse, 40 Foley Square, New York, NY 10007, U.S. versus Luigi Mangione, 25 CR 176. MMG. Judge Garnett, this letter is respectfully submitted on behalf of the defendant Luigi Mangione to request an extension of time to file motions related to the constitutionality of the death penalty and the government's decision to seek the death penalty in this case. Since the arraignment of Mr. Mangione on April 25th, Defense counsel have been working diligently to research and draft appropriate motions in this case and in the parallel case filed against Mr. Mangione in New York County, while also reviewing discovery and working on the mitigation investigation. Additionally, all defense counsel involved in the case have commitments to other cases that must be met. Given the complex nature of the issues in this case and the other ongoing responsibilities involved in preparing this case for trial, defense counsel need additional time to prepare the motions addressed to the death penalty. If acceptable to the court, we propose that the defendant's motions addressed to the death penalty be filed on or before September 19th, with the government's response due by October 31st and the defendant's reply due on November 14th. We further propose that the schedule for additional pre-trial motions be addressed at the next pre-trial conference, currently scheduled for December 5th, 2025. We have discussed this matter with counsel for the government, and although they initially proposed a shorter extension of the motion deadline, upon reflection the parties determined that the requested extension works best for the schedules of all counsel. Thank you in advance for your consideration of this request. Respectfully submitted.
Basically, the reason why they're requesting an extension for the death penalty motion to be filed is basically because the Luigi Mangione's legal team, a couple of people in his legal team have other cases they're working on, because that's what happens with lawyers. They work on many different cases at once instead of like just one case at a time. So some of them must be working on other cases that are coming up a lot more sooner, so they just need to push that further to September. So hopefully this is for the better for Luigi Mangione's case. Better compared to, I remember on Reddit when this first came out, there was a lot of discussion of why is this happening, why is it being extended, and all that. So it was like very interesting to read, honestly. So I've been seeing that a little bit lately. There's been some things coming out for Luigi Mangione's legal team, or just in general for Luigi Mangione's case, and people are just very much going, what's going on? Why is this happening? What? So it's very interesting, honestly. I find that. I've noticed that over the last 2 weeks or so. So hopefully this is for the better for Luigi Mangione's case. June 16th, 2025, the request for the death penalty motion to be extended until September was granted. And I'll put the full document on screen for you guys here.
Request granted. Defendant's motions due by September 19th, 2025. The government's response due by October 31st, 2025. Defendant's reply due by November 14th, 2025. Notwithstanding the extension of the motion's schedule, the court still intends to set a firm trial date at December 5th conference, and all counsel must be prepared for that discussion. The clerk of court is respectfully directed to terminate DKT number 35. So ordered. Dated June 16th, 2025, June 15th, 2025. By E.C.E. Hon, Margaret M. Gamet, U.S. District Judge, U.S. Courthouse 40 Foley Square, New York, NY 10007, Re, U.S. vs. Luigi Mangione 25 CR 176, MMG. Dear Judge Garnett, this letter is respectfully submitted on behalf of the defendant Luigi Mangione to request an extension of time to file motions related to the constitutionality of the death penalty and the government's decision to seek the death penalty in this case. Since the arraignment of Mr. Mangione on April 25th, defense counsel have been working diligently to research and draft appropriate motions in this case and in the parallel case filed against Mr. Mangione in New York County, while also reviewing discovery and working on the mitigation investigation. Additionally, all defense counsel involved in the case have commitments to other cases that must be met. Given the complex nature of the issues in this case and the other ongoing responsibilities involved in preparing this case for trial, defense counsel need additional time to prepare the motions addressed to the death penalty. If acceptable to the court, we propose that the defendant's motions addressed to the death penalty be filed on or before September 19th, with the government's response due by October 31st and the defendant's reply due on November 14th. We further propose that the schedule for additional pre-trial motions be addressed at the next pre-trial conference, currently scheduled for December 5th, 2025. We have discussed this matter with counsel for the government, and although they initially proposed a shorter extension of the motion deadline, upon reflection the parties determined that the requested extension works best for the schedules of all counsel. Thank you in advance for your consideration of this request.
So hopefully this will be in Luigi Mangione's favor. The 18th of June 2025. So on Luigi Mangione's official legal website, it literally just says by electronic file. So this is Luigi Mangione's legal team response for repressing the evidence that police gathered against Luigi Mangione illegally. Then I might mention it is not as long as the 57-page pre-trial motion that we read a month ago, but it is pretty long. It's like 26 pages long, but it's not as long as the last one. Oh my god, but it is still pretty big, so it's a pretty good read. So I'll put it up on screen for you guys.
Supreme Court of the State of New York, 100 Center Street, Part 32, New York, New York 10013 Re, People vs. Luigi Mangione, Ind. Number 75657/2024. Dear Judge Caro, please accept this reply in support of Mr. Mangione's omnibus motion, where we will address 4 points. First, the prosecution has intentionally violated Mr. Mangione's right to a fair trial by unnecessarily publicly releasing his alleged journal. The prosecution did so even though they have already consented to a map hearing, and even though the court already has these materials as a grand jury exhibit. Second, the prosecution has failed to provide legal support for its terrorism-related charges that are both legally and factually unfounded. Third, the prosecution is violating Mr. Mangione's constitutional and statutory rights by attempting to start the state trial before the federal death penalty trial. Fourth, the defense requests the court set a motion schedule for the defense to fully brief the prosecution's demand pursuant to CPL 250.101. The prosecution fails to defend the warrantless search of Mr. Mangione's backpack, yet publicly and selectively releases Mr. Mangione's alleged journal, knowing that the journal may be suppressed. The defense has provided irrefutable evidence that the search of Mr. Mangione's alleged backpack may be illegal, and its fruits may therefore be suppressed. In response, the prosecution preemptively released his alleged Journal 1 to the public. The prosecution's actions further no legitimate objective. First, the court is in possession of these materials as they were included among the grand jury evidence. Second, the prosecution consented to hearings to determine the legality of the searches. If the searches were not lawful, their fruits are not admissible. Nonetheless, the prosecution has cherry-picked the most facially prejudicial information from materials that may never see the light of the courtroom. Why? The only rationale that makes sense is that the prosecution hopes to bias the public against Mr. Mangione and undermine his right to a fair trial. This would be wrong in any case, but it is especially so where, as here, the defendant faces a potential death sentence in federal court for the same exact offense. It is worth noting, and the district attorney should be on notice, that Local Rule 23.1 of the Southern and Eastern Districts of New York provides that releasing information to the public that a lawyer knows is likely to be inadmissible at trial and which would create a substantial one in paragraphs 25 and 26 of the prosecution's response to defendant's omnibus motion. The prosecution twice admits that the red notebook is a diary which is self-evident by its contents. Despite admitting this undeniable fact, and knowing that it may be suppressed, they continue to intentionally prejudice Mr. Mangione by then referring to the diary as a manifesto 17 times throughout their response. On Gregory Caro, June 18, 2025, likelihood of prejudice in IJ, impartial trial presumptively violates the local rule and can result in appropriate consequences. See Local Rule 23L, D. 6. At the federal court arraignment on April 25, 2025, Mr. Mangione invoked Local Rule 23.1 to prevent parties, including the United States Attorney General, from violating his right to a fair trial in the federal death penalty case. As officers of the court, regardless of whether they formally appear in the federal case, the district attorney's representatives should abide by the rules of all courts presiding over cases involving this defendant, especially the rule protecting a defendant's constitutional right to an impartial jury in a death penalty case. Even setting aside Local Rule 23.1, the prosecution should seek to stop, rather than perpetuate, the strategic release of information solely to prejudice Mr. Mangione's right to a fair trial. 2. The prosecution fails to adequately defend the terrorism charges in the indictment. The prosecution makes multiple arguments in defense of its terrorism charges. A. That intent can be inferred by the alleged actions alone. B. That private journal entries confirm intent. And C. The charge of terrorism does not require the intention to harm multiple people. They all fail. A. Terroristic intent cannot be inferred from the alleged act alone. The prosecution argues that Mr. Mangione's terroristic intent can be inferred from his alleged actions alone. To reach this conclusion about Mr. Mangione's alleged state of mind, the prosecution speculates that Mr. Mangione's lack of prior contact with the victim or contractual relationship with United Healthcare demonstrate that he had no personal vendetta. Response at 16. To support its inflated charge of murder in the first degree as an act of terrorism, the prosecution also argues that the alleged murder was not a typical street crime, that is, a murder in the second degree, because the shooter did not allegedly steal the victim's Rolex watch, but this argument fails to consider other alternatives. As just one example, the alleged shooter could have selected the victim because of his individual role in setting policies and priorities at United Healthcare, such as manipulating denial rates to increase revenue, leading to denials in coverage for millions of Americans. In such a scenario, the alleged shooter would have targeted the victim to stop his actions and not to violently broadcast a social and political message to the public at large. Response at 16. Accordingly, the facts surrounding the alleged shooting failed to establish that the conduct was intended as terrorism. B. The private writings attributed to Mr. Mangione do not confirm terroristic intent. The prosecution next argues that the private journal entries it attributes to Mr. Mangione prove terroristic intent. This is wrong for 3 reasons. First, the prosecution conflates the concept of a private ideological motivation with the specific intent to intimidate, coerce, or influence a civilian population required to sustain a terrorism count. Second, the charged crime is indistinguishable from the over 100 firearm homicides that occur each year in New York City absent law enforcement's public broadcasting of the writings. Third, the public response that the prosecution claims is the natural and probable result of the alleged act is a consequence of law enforcement's premature and improper disclosures. not the perpetrator's actions. I. The writings that the prosecution claims are evidence of terroristic intent show only a private motive. The prosecution claims that the writings it attributes to Mr. Mangione are evidence of terroristic intent, citing only statements of the author's disdain for the insurance industry. A showing of terroristic intent requires more. Penal Law Section 490.05 provides 3 ways that someone can commit an act of terrorism. 1. With intent to I. Intimidate or coerce a civilian population. 2. With intent to 2. Influence the policy of a unit of government by intimidation or coercion. Or 3. With intent to 3. Affect the conduct of a unit of government by murder, assassination or kidnapping. The statute makes clear that the fundamental characteristic of what makes an act a terrorist act, by any common sense definition, is the forward-looking nature of the crime. A terrorist seeks to affect the future. He looks to either cow a civilian population or government unit into hewing to certain standards of behavior based on a fear of future violence taking place. Terrorist organizations, for example, intimidate civilians by blowing up buses because people need to take the bus the next day and have to worry about being the next victim. That is the harm that PL Section 490.0 I is directed at preventing. Much like the charged act itself, the alleged writings could just as easily be interpreted as a personal vendetta, and not an intent to change the behavior of others through fear. The prosecution spills much ink reciting alleged statements characterizing the health insurance industry as a deadly greed, fueled health insurance cartel, and the conference as an annual parasitic bean counter convention, without explaining how these amount to anything more than a privately held viewpoint. A viewpoint also held by thousands of people who have since publicly shared their stories of anger and frustration with private health insurance. The conclusory argument that these alleged journal entries demonstrate an intent to intimidate all employees of the health insurance business, response at 17, is purely speculative and makes no attempt to reconcile the author's past-looking statements with the forward-looking intent that the terrorism statute requires. Contrast this with the defendant in the case cited by the prosecution, Ali Hassan Abu Kamal, who spoke about his hatred for Americans, British people, French people and Zionists, saying they were responsible for turning our people, the Palestinians, homeless, and continued that his restless aspiration is to murder as many of them as possible. Response at 27. But in Abu Kamal, the intent was clear because the defendant explicitly declared an intent to threaten a civilian population by inspiring other killings. Indeed, the claim that Mr. Mangione sought to bring about revolutionary change in the healthcare industry and to abolish health insurance companies is wholly fabricated by the prosecution and appears nowhere in any of the writings. The prosecution completely ignores other journal writings that explicitly state that a terrorist is the worst thing a person can be. 2. Without public broadcasting, the alleged homicide is indistinguishable from the hundreds of murders that occur each year in New York City. That the private writings cited by the prosecution were never publicly disseminated by the perpetrator demonstrates a lack of intent to intimidate, coerce, or influence a protected population, nor has the prosecution pointed to any public writings attributable to Mr. Mangione despite an extensive history of public expression on social media. The prosecution has not alleged that Mr. Mangione has publicly broadcast any of the messages law enforcement attempts to attribute to him. Mr. Mangione has not posted any such messages on his social media pages. He has not encouraged others to participate in similar acts. Indeed, nothing Mr. Mangione has allegedly done is evidence that he intended to bring about revolutionary change to the healthcare industry. Response at 18. Without public statements, this particular murder is indistinguishable from others and therefore cannot satisfy the precise definition of an act of terrorism under the statute. It does not meet the statutory requirements because there is no forward-looking motivation alleged. Though the prosecution claims that the alleged factual pattern is not a typical street crime, it shares with those crimes one fundamental characteristic. As alleged, it was completed once the act was carried out. It was not motivated by seeking to change the future in some way, as the terrorism statute requires. 2-3. Any public response is a consequence of law enforcement's actions and is not a natural and probable consequence of the charged act. The prosecution claims that Mr. Mangone's intent is obvious from the natural and probable consequences of his act. Response at 18. This argument is purely speculative and relies on the false premise that Mr. Mangione must have intended to inspire threats against insurance workers simply because such threats occurred after the alleged murder. But the public response to the charged crime demonstrates more about the frustrations many Americans harbor against the medical insurance industry than it does about Mr. Mangone's alleged intent to inspire others through the threats against insurance workers can hardly be considered a natural and probable consequence of the alleged act. After indicting Mr. Mangione, the prosecution released a public statement to nor can the prosecution rely on the public servant sections of Law 125.27, as in the United States. Unlike any other industrialized nation, the top leaders of the largest health system in the country, who makes more than $10 million per year, is not considered a public servant. 3. Because the district attorney's office claims that the subsequent threatening conduct by others is an intended consequence of Mr. Mangone's alleged actions, we request, pursuant to Brady v. Maryland, 373 U.S. 83, 1963, that the district attorney's office promptly disclose any evidence in the prosecution's possession or custody of threats to United Healthcare or of expenditures on the part of United Healthcare for the protection of its employees prior to December 4, 2024. In fact, as has been widely reported, United Healthcare and the alleged victim had been subject to numerous threats prior to December 4, 2024, and many United Healthcare executives had private security details as a result, characterizing the public response, including threats, as shocking. For if they were shocking to the prosecution, why would they not be shocking to Mr. Mangione too? Public threats to United Healthcare are hardly the natural consequence of the shooting, as such threats existed prior to December 4, 2024. For example, on page 398 of the grand jury minutes, after the prosecution had finished questioning the witness, a grand juror asked about prior threats received by United Healthcare. In response, the witness testified that someone from northern Minnesota made a threat and it was about a denial by United Healthcare. This was in the beginning of November. We looked into it. Specifically, it involved a denial for a couple $100 for an MRI. The prosecution's theory is disproven by its own allegations. As stated above, the prosecution has never alleged that Mr. Mangione ever released a single statement encouraging others to act out against or threaten insurance company employees. Indeed, after listening to dozens of Mr. Mangone's recorded phone calls, including an minute attorney-client call, the district attorney has not alleged a single instance when Mr. Mangione attempted to inspire anyone to commit any violence whatsoever. 5. Law enforcement has only itself to blame for the situation that it has created by releasing private journal writings and other information that would not have otherwise become public. 6. To illustrate this point, the specific threats referenced in the grand jury mirrored the language publicly released by law enforcement and which differed from the actual words written on the bullets. According to the prosecution, the bullets they recovered said delay, depose, but initially, law enforcement stated that they said deny, defend, depose. 7. On December 17, 2024, a 4 Manhattan District Attorney's Office, Watch, DA Bragg and NYPD Commissioner Tisch announced murder indictment of Luigi Mangione, December 17, 2024, https://manhattan.org. Watch DA Bragg to make law. Enforcement announcement with NIPT Commissioner, at 9:15. 5. It is unclear why the prosecution's motion twice references a Give Send Go fundraising website created by people wholly unconnected to Mr. Mangione. It is worth noting that despite law enforcement's attempts to portray Mr. Mangione as a terrorist and revolutionary anarchist intending to inspire violence, over 30,000 different people have donated to his fund, leaving positive messages. In fact, the top 5 words left in the comments section of the fund are love, hope, support, people, and free. See https://lookastudio. google.com U0/reporting F8EA035E951 to 498 EB77 CEC IB97L ETA 0/page/P S6W0s JERD S equals LF88 E353 FO6. In its response, the District Attorney's Office twice listed Mr. Mangone's social security number, as well as his driver's license number and a previous home address where civilians reside who are not connected to this case whatsoever other than happen to currently live at this previous address. This is not the first time the District Attorney's Office has listed private information in its public filings. On April 25, 2025, the District Attorney's Office publicly listed Defense Counsel's personal cell phone number in its letter to the court attempting to defend its improper monitoring of a legal call between counsel and Mr. Mangione. After publicly filing these documents and disseminating them to the media, although the District Attorney's Office agreed, on counsel's request, on both occasions to redact the sensitive information and refile, unfortunately, after it had already been publicly filed and widely circulated by them, on counsel's request, the damage was already done as the District Attorney's Office had already sent the unredacted versions to major press outlets. While we can appreciate that mistakes happen, after all, the District Attorney's Office has previously failed to properly redact witness names in its discovery productions, we are concerned by the emerging pattern. We therefore request that this court issue a prospective order reminding the District Attorney's Office to abide by 22 NYCRR Section 205, which requires the redaction of social security numbers as confidential personal information. We also urge the District Attorney's Office to be more cautious, use its common sense and refrain from divulging other personal identifying information in its public filings. United Healthcare executive testified before the grand jury, stating that there were social media posts quoted deny, defend, depose, response at 18, the words law enforcement disseminated. Despite this language, the prosecution further eschews responsibility for the public response, arguing, UHC was not the only insurance company targeted. Posters threatening Emblem Health's CEO were posted and that others stated, healthcare CEOs should not feel safe. Deny, defend, depose on social media. Response at 20, that these threats used the exact words that law enforcement publicly disseminated and not the words on the evidence itself shows what, exactly, caused any public reaction. The prosecution may not now use the consequences of its own actions to support charging Mr. Mangione with terrorism. See, the terrorist statute requires an intent to harm multiple people. The prosecution argues that murder as an act of terrorism, count 1, does not require multiple victims. But this argument fails to address the defense's argument that this charge requires the intent to harm multiple people. In People v. Morales, 20 NY 3D 240, 2012, the Court of Appeals held, the legislative history, and the context within which this law was passed demonstrate that it was only intended to apply to a very narrow category of the most serious offences, and only when they meet certain criteria similar to the following terrorist attacks. 1. September 11, 2001 attacks on the World Trade Center and the Pentagon. 2. The bombings of American embassies in Kenya and Tanzania in 1998. 3. The destruction of the Oklahoma City Federal Office Building in 1995. 4. The mid-air bombing of Pan Am Flight No. 103 in Lockerbie, Scotland in 1988. 5. The 1997 shooting from atop the Empire State Building. 6. The 1994 murder of Ari Halberstam on the Brooklyn Bridge, and 7. The bombing at the World Trade Center in 1993. Omnibus Moet. R. 8485. In these examples, the alleged perpetrator, S, targeted numerous individuals. In other words, the defendants there intended to harm multiple people. Whether or not they succeeded is of no moment. The prosecution's argument that the 1994 shooting on the Brooklyn Bridge and the 1997 shooting at the Empire State Building each resulted in just one victim entirely misses the point. The perpetrator in the 1994 case shot numerous bullets into a van filled with 15 Jewish students, killing 16-year-old Ari Halberstam and injuring 3 other students, intending to harm multiple people. Similarly, the perpetrator in the 1997 shooting atop the Empire State Building killed 1 person and shot 6 others. The fact that the prosecution's two cited examples involve injury to multiple people supports the argument that this charge requires the intent to harm multiple victims. In fact, the prosecution does not cite to a single case involving a terrorism charge where both the intent and act involved harm to a single individual. In both those cases, similar to the other terrorist attacks listed by the New York legislature, the perpetrator's conduct was directed at numerous individuals. In contrast, the prosecution here alleges a single target, that it was a wealthy CEO of an insurance company who wore a Rolex A-point. The district attorney's office raised several times in its response does not turn the alleged shooting of one individual into an act of terrorism under New York's Law 8. To maintain a charge of murder as an act of terrorism, there must be an intent to harm numerous individuals, irrespective of the ultimate result. The prosecution has failed to sufficiently allege this requisite intent. Pointing to portions of Morales, the prosecution claims that intent to harm a single person is sufficient. Response at 2122. But the cited language proves the opposite point. The decision notes refer to the assassination of person i.e., conduct directed at multiple individuals and not the assassination of a single person. Furthermore, as the prosecution admits, the journal entries attributed to Mr. Mangione clearly and specifically denounce terrorism and indiscriminate killing of innocents, stating that a terrorist is the worst thing a person can be. Response at 28. Lind vs. Arab Bank plc, 882 F, 3D 314, 326, 2DC 2018, does not help the prosecution either. The prosecution argues that by allegedly targeting the CEO of an insurance company, Mr. Mangione sought to both influence government policy and intimidate or coerce a civilian population. But Lind involved a suicide bombing targeting civilians, perpetrated by a member of Hamas, and is readily distinguishable. There, the act was part of a terrorist organization's publicly stated mission to influence the Israeli government's position in the decades-long Israeli-Palestinian conflict. In contrast, Mr. Mangone's alleged actions relate to a single, isolated event targeting one individual. Notably, the U.S. Attorney's Office did not charge Mr. Mangione with terrorism, and New York State's terrorism law was modeled after the federal terrorism statute. By continuing to refer to Mr. Mangione as a terrorist and a revolutionary anarchist, the prosecution ignores the evidence in its possession that directly refutes its theory. 9.3. The district attorney's office is violating Mr. Mangone's constitutional rights by demanding the state trial proceed before the federal trial. A federal prosecution seeking the death penalty raises constitutional concerns distinct from those in a typical case of dual prosecution. Mischaracterizing the defense's position, the prosecution states that Mr. Mangione raises the novel argument that this case should be delayed indefinitely because his concurrent state and federal prosecutions violate various constitutional rights. Response at 45. But the constitutional concerns arise from more than just concurrent prosecutions. The violations result from defending a non-capital state prosecution at the same time as a federal death penalty case with different charges that require different defenses for the identical set of facts. In fact, based on our research, there has never been a case anywhere in this country in support of its own strawman argument that New York's terrorism laws do not require the murder of multiple victims. The district attorney's office cites to PL section 125.27 I.2. 13, which refers to a singular victim who is killed in furtherance of an act of terrorism. Response at page 25. While accurate, this recitation of the statute is irrelevant because, as noted above, the issue here is not whether one or more people were killed in the alleged shooting, but whether the shooting was an act of terrorism. As noted in Morales, the legislative intent was clear that the terrorism statutes were only intended to apply to a very narrow category of the most serious offenses similar to the 7 listed above. Morales, 20 NY, 3D at 249. The alleged shooting in this case does not meet that criteria. 9. In the context of the journal writings, it is clear that the writer refers to another person, not themselves. A modern era where a non-capital state prosecution proceeded before a concurrent federal death penalty case. 10. Opposing the defense's request for the federal case to proceed first, the prosecution argues that it is disingenuous for defendant to claim that he is required to defend both cases at the same time because trial on the state charges is imminent and will be completed several years before any federal trial begins. Response at 46. This explanation is misguided for 3 reasons. First, in its drive to bring the state case to trial before the federal trial, the prosecution seeks to artificially accelerate pre-trial proceedings beyond what is typical in similar murder cases. People v. Pedro Hernandez, which involved the murder and kidnapping of Int and Pats, took over 2.5 years before proceeding to trial. In People v. Pamela Butchbinder, the case proceeded for nearly 5 years before a guilty plea was entered. In People v. Nicholas Brooks, which involved the Soho House murder of Sylvie Cache, the prosecution took over 2.5 years before the case proceeded to trial. And in People v. Alex Ray Scott, nearly 4 years passed before the defendant pleaded guilty to the alleged dating app murder. Second, the prosecution's argument demonstrates a complete lack of understanding of how federal death penalty cases proceed. While a trial in the federal death penalty case might not happen quickly, there is considerable work that must be done by a defendant challenging a federal death penalty case. As defense counsel noted in Mr. Mangone's omnibus motion, significant motion practice is required in federal death penalty cases, on top of the usual motions filed in every other federal criminal case. In addition, counsel is required to conduct a significant mitigation investigation into the defendant's life. This investigation takes considerable time and effort. If the state case proceeds first, all the work required in a federal death penalty case, including the extensive motion practice and mitigation investigation, would be forced to take place at the same time as the state court proceedings. Although the district attorney's office makes light of this situation by stating that Mr. Mangione can hire a different attorney to handle one of his cases, response at 56. The prosecution conveniently forgets that Mr. Mangione has a constitutional right to participate in his own defense. 11. By having both cases proceed at the same time, Mr. Mangione will not be able to participate in reviewing discovery and preparing for trial in the state case while simultaneously assisting counsel in its mitigation investigation and motion practice against the death penalty. This is particularly true in this case where the state has provided approximately 9.7 terabytes of information, which Mr. Mangione must review with counsel to meaningfully defend himself. 12. Even if counsel could be ready to try this case in the prosecution's proposed timeline, which it cannot, it would violate Mr. Mangone's right to testify in his own defense. The District Attorney 10. The District Attorney's Office cites People v. Matter as an example of a case where the state's attempted murder prosecution proceeded before the defendant's federal terrorism case. However, Matter was not facing the death penalty in federal court. Accordingly, Matter is irrelevant. 11. The District Attorney's Office also ignores that Mr. Mangione is entitled to counsel of his choice. 12. ChatGPT estimates that the estimated time to review 9.7 terabytes of data at a typical rate is 337 to 675 days for text documents, 156 to 260 hours for images, and 2,000 to 3,000 hours for videos. Once again misstates our position by claiming that the defense would commit perjury and testify differently. Response at 51. Again, the prosecution misses the point. Should Mr. Mangione testify in the state case, that testimony could then be used as evidence against him in a capital case. One testimony, used twice, one of which could be used to execute him. The Supremacy Clause of the United States Constitution precludes New York from infringing on rights afforded to Mr. Mangione when the death penalty is on the table, even where, as here, the prosecutors may have once agreed the state case would proceed first. 13. We attach to this response as Exhibit A, a sworn affirmation by learned counsel Avram Moskowitz, who has been assigned to represent Mr. Mangione as co-counsel in his capital prosecution, for this court's consideration. We respectfully offer this information to supplement the court's understanding of what defending a death-eligible case entails, and to inform the court of the life or death implications of these parallel prosecutions. Third, there should be no harm to the district attorney's case should the federal case proceed first, since, according to the district attorney, the state case would proceed even after the conclusion of the federal case and would not implicate Mr. Mangone's protections against double jeopardy. Response at 48. Federal and state statutes are directed to different evils and involve targeting different victims. Given the district attorney's position that the state and federal trials do not affect each other, there is no downside for state prosecutors to try their case after the federal prosecution. This would prevent any prejudice to Mr. Mangione in the death penalty case and afford him the rights to which he is entitled. Despite these legitimate concerns, the prosecution continues its breathless demands to move this case at an atypically fast pace, given its complexity. In recent correspondence with the court, the prosecution continues to rush for no reason. They ignore the fact that the defense is conducting its own investigation. They seek to hold virtual hearings, even where the court has not set an appearance, notwithstanding that Mr. Mangione will not consent to any virtual appearances and insists on being present. The prosecution's stated reasons for fast-tracking this case are a thinly veiled attempt to hide its actual motivation to bestow upon itself the opportunity to try a highly public and closely followed trial before its federal counterpart. 14. The prosecution reiterates these unreasonable demands in its response, suggesting that Mr. Mangione forego his constitutional rights and instead give way to state's preferences by using the more than 30,000 individual donations he has received to hire different counsel, not of his choosing. Mr. Mangione declines this suggestion. The prosecution's fixation with Mr. Mangone's legal fund mentioned twice in its response ignores the defense's stated concerns, which relate. 13. District Attorney incorrectly states that he agreement between the federal prosecutor and this office that the state case proceed first. Response at page 49. However, the statement, made by then acting United States Attorney Ed Kim, was that the state case is currently expected to proceed to trial prior to the federal case. That statement was made by the prior Department of Justice administration, and prior to its filing a notice of intention to seek the death penalty. According to the current federal prosecutors, there is no such agreement that the state case proceeds first. 14. Despite the prosecution's work on this case, detailed at length in its response, under the prosecution's logic, the Pennsylvania prosecution should go to trial first. After all, it was the McDonald's worker and Pennsylvania law enforcement who arrested Mr. Mangione, not law enforcement personnel from this jurisdiction, to process, not funding. The prosecution fails to grasp that Mr. Mangione might be foreclosed from raising certain defenses should the state case proceed first, with execution as a potential consequence. There is no greater prejudice. After all, death is different. For the defense requests the court set a motion schedule for the defense to fully brief the prosecution's demand, pursuant to CPL 250.10. The prosecution continues to attempt to rush this court's process. This is improper and invites error. It is also contrary to the court's prior statements. At February 21, 2025 conference, the court discussed explicitly how motions would be made, set a date for initial motions, and made clear to the parties that you could always supplement your motions, but it's got to start. February 21, 2025 TR at 11:12. Pursuant to the court's directions, the defense has made its initial motions, but additional topics must be briefed. For example, the prosecution continues to push the issue of CPL 250.10 notice, but the prosecution's demands ignore the serious issues raised by the procedural posture of this case, a posture that, for decades, has been held to be unconstitutional, as the double jeopardy clause of the Fifth Amendment, is an insurmountable barrier to two prosecutions arising out of the same events. Petit versus United States, 361 U.S. 529, 533, 1960, Brennan, J. Concurring. See also, for example, Rinaldi versus United States, 434 U.S. 22, 2829, 1977, observing that in response to the Supreme Court's continuing sensitivity to the fairness implications of the multiple prosecution power, the Justice Department adopted the policy of refusing to bring a federal prosecution following a state prosecution, except when necessary to advance compelling interests of federal law enforcement, and holding that the Petit policy was designed to limit the exercise of the power to bring successive prosecutions for the same offense to situations comporting with the rationale for the existence of that power, and serves to protect interests which, but for the dual sovereignty principle inherent in our federal system, would be embraced by the double jeopardy clause. For reasons that should be obvious, The defense is not going to serve notice under CPL 250.10, but maintains its right to serve such notice at a time that will not prejudice any of Mr. Mangone's rights. The defense will set forth its reasons for this in a separate motion. We anticipate that such a motion might, among other things, raise the profound Fifth Amendment problems with the prosecution's apparent position on various issues in this case. But the time for such a motion has not yet ripened. Our point is simply that the court, and not the prosecution, will dictate the schedule in this matter, and we ask, respectfully, that this schedule reflect consideration for the profound constitutional issues that the prosecution's actions have created. When, as here, the government refuses to follow its own policies, issues arise such as the CPL 250.10 issue here. They must be briefed fully and carefully, for if the government is willing to trample on Mr. Mangone's rights, the court must be able to restrain it. Conclusion: for the reasons set forth in this reply and in our omnibus motion, we respectfully request that this court grant the requested relief. Avram C. Moskowitz, under penalties of perjury, affirms and states: 1. I am a partner in the law firm of Moskowitz, Colson, Ginsberg and Schulman, LLP 2, Chapter 6, Section 620.30 of the Judicial Conference of the United States Criminal Justice Act Guidelines and 18 U.S.C. Section 3005 provide for the assignment of learned counsel to assist in the representation of federal criminal defendants who are charged with capital crimes. I have been appointed as learned counsel to represent Luigi Mangione in U.S. v. Mangione, 25 CR 176, MMG, currently pending in the United States District Court for the Southern District of New York, hereinafter the federal case or the capital case, pursuant to those authorities. In that capacity, I am serving as co-counsel to the firm Anafilo Intrater LLP, which has been retained to represent Mr. Mangione in the federal case and in a parallel state prosecution, People v. Luigi Mangione, 75,657/24, pending in the New York State Supreme Court, New York County, hereinafter the state case. 3. A copy of my resume is attached hereto as Exhibit 1. Briefly summarized, I received a bachelor's degree from Yeshiva University in 1977 and a JD from Columbia University in 1980. After graduating law school, I spent 5 years in private practice at 2 different law firms in New York City before being appointed an assistant United States attorney in the Southern District of New York, a position I held from October 1985, March 1991, during which time I tried 24 cases to verdict. After leaving the U.S. Attorney's Office, I rejoined my prior firm, Anderson, Kill & Olick, for 5 years before starting my own firm, a litigation boutique, where I specialized in criminal defense work. From 1991 until today, I have been a member of the Criminal Justice Act panel in both the Southern and Eastern Districts of New York. Since 1991, I have tried more than 24 criminal cases to verdict in federal and state courts. 4. I have been a member of the capital panels in both the Southern and Eastern Districts of New York since 1998. In that capacity, I have represented more than 50 defendants facing murder charges that were death eligible, either as lead trial counsel or as learned counsel. In each of those cases, I have been involved in conducting mitigation investigations on behalf of my clients. Of the numerous clients I have represented in death-eligible cases, only 3 were authorized for capital prosecutions. In 2 of those authorized cases, my client ultimately was allowed to plead guilty before trial. In the 1 capital case that went to trial, my client received a life sentence from the jury. 5. I submit this affirmation in support of Mr. Mangone's motion to stay the trial of the state charges filed against him in this court, pending resolution of the federal prosecution against him, and to provide the court with information concerning federal procedures in capital cases and the constitutional concerns that give rise to those procedures. 6. Because the federal case alleges a capital offense, and because the government has given notice that it intends to seek the death penalty, the federal case gives rise to heightened constitutional concerns. To be constitutionally effective, Mr. Mangone's federal counsel are required to conduct an extensive and thorough mitigation investigation to develop all possible reasons why he should not be executed, and that investigation must be completed in advance of other strategic decisions. because making strategic decisions before receiving and analyzing the information developed during the mitigation investigation might compromise the defendant's ability to present his best mitigation defenses at the sentencing phase of his capital case. Making such decisions before completion of the mitigation investigation would constitute ineffective assistance of counsel and would violate Mr. Mangone's constitutional rights in the federal case. 7. Because they arise out of the same facts and will involve the same witnesses and other evidence, the federal case and the state case are interlinked, such that strategic decisions made in one case will necessarily dictate the defense strategies available in the other case. Accordingly, if Mr. Mangione proceeds to trial in the state case before the federal mitigation investigation is complete, counsel will necessarily be required to make strategic decisions that will be controlling in the capital case without benefit of the information that will be developed over the course of the mitigation investigation. Should trial of the state case proceed before completion of the mitigation investigation and the trial of the federal case, Mr. Mangone's counsel may make decisions in the state case that would not be made if the mitigation evidence was known and the penalty phase of the capital case completed. Because of the linkage between the two cases, those decisions will foreclose counsel from making different choices in the federal case, thereby prejudicing Mr. Mangone's defense in the capital case and depriving him of his Sixth Amendment right to the effective assistance of counsel. 8. This court should not risk compromising Mr. Mangone's constitutional rights by requiring counsel to make possible life or death decisions without the benefit of the critical information that will be developed by the mitigation investigation. The mitigation process in federal death penalty cases. 9. Counsel's duty to conduct a thorough mitigation investigation before making strategic decisions in a capital case is well established. 5 decisions of the Supreme Court of the United States have confirmed trial counsel's duty to conduct a thorough mitigation investigation in a death penalty case. Williams v. Taylor, 529 U.S. 362, 2000. Wiggins v. Smith, 539 U.S. 510, 2003. Rompilla v. Beard, 545 U.S. 374, 2005. Porter v. McCollum, 558 U.S. 30, 2009, Hercurium, and Sears v. Upton, 561 U.S. 945, 2010, Hercurium. 10. In 2003, the same year as the Supreme Court's decision in Wiggins, the American Bar Association issued its revised guidelines for the appointment and performance of defense counsel in death penalty cases. Those guidelines, which summarize the prevailing professional norms in capital defense, have been widely circulated and discussed at capital training seminars ever since. Supplementary guidelines for the mitigation function of defense counsel in death penalty cases, published in 2008, elaborate on these duties. The ARBAR death penalty guidelines and supplementary mitigation guidelines have received particular recognition in federal court, both for federal defender organizations and counsel appointed under the Criminal Justice Act. The Defender Services Program adopted a specific strategy for capital representation, stating that appointed counsel should comply with the 2003 ARBAR guidelines for the appointment and performance of defense counsel in death penalty cases and the 2008 supplementary guidelines for the mitigation function of defense teams in death penalty cases. The Judicial Conference of the United States endorsed similar language in its October 2016 Model CJA Plan 11. The 21st century editions of the ARBAR guidelines and the supplementary guidelines for the mitigation function highlighted what capital defenders have long recognized. A team should be assembled to begin the mitigation investigation at the earliest opportunity. The need to establish the team as early as possible stems from the complexity of capital defense representation. A mitigation investigation must begin early if it is to be effective. It is a slow, time-intensive process involving the interaction between documentary records and witness interviews. Indeed, mitigation interviewing is itself a lengthy, cyclical process that requires building trust and rapport with the client and witnesses. Earning trust takes time, and a mitigation investigation is built on trust between the investigators and those they interview. Without trust, interviewees are not likely to share the kinds of sensitive information that is often most critical in mitigation. 12. The cyclical process of rapport building applies to clients and potential mitigation witnesses. Only through patience, attention and the rigorous practice of building trust and rapport through multiple, in-person, one-on-one interviews can an investigator elicit a full and candid picture of the client's developmental years, social influences, and mental vulnerabilities. As Russell Stetler, the recently retired Dean of Mitigation Specialists, and his colleague Professor W. Bradley Wendell have explained, the mitigation process is counterintuitive for both defendants and witnesses. One fact: witnesses understand why they are being interviewed. They are percipient witnesses to an event. For example, the light was green or the light was red. Mitigation witnesses, by contrast, are slice-of-life witnesses who observed the client over a period of months or even years and may have shared traumatic experiences. 2. They do not even think of themselves as witnesses. They know nothing about the capital offense, and everything about the mitigation investigation is as counterintuitive for witnesses as it is for the client. 13. In a declaration recently filed in a capital case pending in the District of Maryland, Mr. Stetler, the National Mitigation Coordinator for the Federal Death Penalty Projects from 2005 until 2020, explained the purpose and nature of capital mitigation investigations as follows. The purpose of a thorough mitigation investigation is to develop social history evidence that will humanize the defendant, help jurors to understand why he may have committed the capital offense, and evoke compassion and empathy by identifying in the client's individual frailties that at once established human kinship. And one Russell Stetler and W. Bradley Wendell, Mitigation Reports in Capital Cases, Legal and Ethical Issues, 13 St. Mary's J. on Legal Malpractice and Ethics 48, 2023. The paper was originally presented at the journal's 22nd Annual Symposium on Legal Malpractice and Ethics on January 27, 2023, in San Antonio, Texas. 2 ID at 102. Expose vulnerabilities and disadvantage. Moreover, a thorough social history investigation provides the foundation for reliable mental health evidence and enables counsel to make informed decisions about what kinds of mental health experts to consult and what questions they should address. Mental health experts, in turn, require social history information to conduct a complete and reliable evaluation in the wide spectrum of areas that they may address in a capital case, which range from the statutorily defined issues of competency and criminal responsibility to the broadest varieties of statutory and non-statutory mitigation that have mental health aspects. The fruits of a thorough mitigation investigation not only provide capital defendants with the effective representation to which they are entitled under the Sixth Amendment, but assure jurors of the opportunity to consider all the evidence relevant to the reasoned moral judgment they are asked to render, thereby also assuring the courts of an outcome that is reliable and just. Emphasis added. The need to investigate mental disorders and impairments in the context of sentencing evidence is equally well established. Siak v. Oklahoma, 470 U.S. 68, 80, 1985. Due process right to psychiatric assistance when mental condition is relevant to culpability or punishment. Without the social history that results from a thorough mitigation investigation, trial counsel cannot make an informed and thoughtful decision about which experts to retain in order to gauge the nature and extent of a client's possible mental disorders or impairments. Mental health experts, in turn, require social history information for complete and reliable assessments, so consultations without such background information are inevitably futile. Emphasis added. Declaration of Russell Stetler in U.S. versus Costanza Goldamez, 22 CR 409, SAG, DMD, ECF Doc, number 1017, May 27, 2025, 14. Significantly, since 2000, the Supreme Court has overturned 5 death verdicts based on the failure of trial counsel to conduct a thorough mitigation investigation. Williams v. Taylor, 529 U.S. 362, 2000. Wiggins v. Smith, 539 U.S. 510, 2003. Rompilla v. Beard, 545 U.S. 374, 2005. Porter v. McCollum, 558 U.S. 30, 2009, Hercurium, and Sears v. Upton, 561 U.S. 945, 2010, Hercurium. In Wiggins, Supra, the Supreme Court threw out a death verdict and found counsel's performance deficient, even though they had the defendant examined by a mental health professional. because they failed to complete a thorough social history investigation as required by the ARBA guidelines. 15. In language that resonates in this case, where the people are rushing to try Mr. Mangione before the defense has had an opportunity to complete its mitigation investigation, the Supreme Court criticized counsel's performance, noting that despite these well-defined norms, however, counsel abandoned their investigation of petitioner's background after having acquired only rudimentary knowledge of his history from a narrow set of sources. 539 U.S. at 524. In Rompilla, Supra, trial counsel were found to be ineffective, even though they were told by the defendant and his family members that there was no mitigating evidence available, and despite the fact that they consulted 3 mental health experts. Finally, in Porter, Supra, the Supreme Court found counsel's performance deficient, finding that the fact that the defendant was fatalistic and uncooperative did not obviate the need for defense counsel to conduct a mitigation investigation. ID 558 U.S. at 40. 16. The parallel prosecutions of Mr. Mangione in state and federal court have placed defense counsel and Mr. Mangione in an untenable position, especially if the state court case proceeds to trial before the capital case. Although based on different legal theories, both cases are based on the identical facts surrounding the same incident. Obviously, defense counsel's primary obligation is to prevent Mr. Mangione's execution. Thus, counsel cannot make any decisions or offer any defenses in the state case that will adversely impact the defense in the capital case. Conversely, although the prosecution of Mr. Mangione in this court does not expose him to the death penalty, he is facing the potential of life in prison without the possibility of parole, the most severe punishment available in New York State 17. Given the severity of the charges against Mr. Mangione in the state case, it is also incumbent on defense counsel to try to avoid making decisions in the federal case that will adversely impact the defense in the state case. Simply put, counsel must coordinate the defenses in both cases so that positions taken and evidence offered by the defense in one case do not adversely affect the defense in the second case. Failure to coordinate the defenses offered in the two cases would be malpractice, especially if decisions made in defending the state case adversely affected the capital case and resulted in a death sentence for Mr. Mangione. 18. Finally, given the central role that the mitigation investigation plays in helping counsel formulate a defense against the capital charges, counsel for Mr. Mangione cannot decide on a trial strategy for either the state or federal case until the mitigation investigation has been completed and until counsel has consulted with any experts that they determine are necessary based upon the results of the mitigation investigation. Requiring counsel to proceed to trial in the state case before completion of the mitigation investigation in the capital case would force them to make strategic decisions without all the information they need to make reasoned decisions, and thus, any such decisions are likely to prejudice the defense of the capital case. Most significantly, as recognized by the Supreme Court in the cases cited above, if counsel for Mr. Mangione made strategic decisions before they have completed the thorough mitigation investigation required by the ARBA guidelines, their performance will be considered ineffective and will deprive Mr. Mangione of his Sixth Amendment right to the effective assistance of counsel. 19. Even the Department of Justice recognizes the importance of conducting a fulsome defense mitigation investigation, even as early as the charging phase. In virtually all death-eligible cases charged in federal court, the defense is given an opportunity to conduct a mitigation investigation and make a mitigation submission to the Department of Justice before the decision is made on whether the government will seek the death penalty. In my experience representing more than 50 death-eligible clients, mitigation investigations usually take well over a year to complete. In some cases, where obtaining records and finding and interviewing potential mitigation witnesses proved challenging, the mitigation investigation continued for more than 2 years before a charging decision was made. In cases where the government decides to seek the death penalty, the mitigation investigation continues up to and through the trial. In this case, the Department of Justice departed from those usual practices. Attorney General Bondi announced that the government would seek the death penalty against Mr. Mangione shortly after I was appointed as learned counsel and before I had an opportunity to retain mitigation specialists to begin the mitigation investigation. 20. A mitigation investigation cannot be completed in a predetermined amount of time. As Mr. Stetler eloquently explained in his declaration in the Constanza Galdames case, A social history cannot be completed in a predetermined time frame. Several years ago, I noted, the most recent scholarly estimate of the time required for thorough mitigation investigation is that it often takes thousands of hours to complete the extraordinarily difficult and time-consuming task. In addition to the bureaucratic obstacles to the acquisition of essential documentation, it takes time to establish rapport with the client, his family, and others who may have important information to share about the client's history. It is quite typical, in the first interview with clients or their family members, to obtain incomplete, superficial, and defensive responses to questions about family dynamics, socioeconomic status, religious and cultural practices, the existence of intrafamilial abuse, and mentally ill family members. These inquiries invade the most shameful secrets of the client's family, expose raw nerves, and often re-traumatize those being interviewed. 21. Counsel for Mr. Mangione and the mitigation specialists working with counsel are working diligently to collect all available records and conduct interviews of every person who may have information relevant to possible mitigation. At this early stage in the investigation process, it is impossible to predict how long it will take to conclude the investigation. What is clear, however, is that rushing the mitigation investigation to meet an arbitrary trial date or forcing counsel to make life and death decisions without the benefit of a thorough mitigation investigation would render counsel ineffective and would violate Mr. Mangione's Sixth Amendment right to the effective assistance of counsel. 22. Rushing the state court case to trial before the federal capital trial would also force the defendant to compromise his Fifth Amendment rights and the protections afforded to him by Fed. Akrim. P 12.2, Rule 12.2 inches. For example, in Estelle versus Smith, 451 U.S. 454, 101 SCT 1866, 1981, the court ordered the defendant to take part in a pre-trial competency hearing, and prosecutors used the statements he made during that hearing against him in the penalty phase of his capital trial because the defendant was not warned prior to the examination that his statement could be used against him in such fashion. The court found that the use of his statements during the penalty phase violated the defendant's Fifth Amendment rights. ID 23. Federal Rule of Criminal Procedure Rule 12.2 is intended to protect a defendant's Fifth Amendment rights in connection with mental health evaluations and to prevent constitutional violations like that in Estelle. The rule provides that if a defendant intends to offer expert testimony relating to any mental condition of the defendant bearing on the issue of punishment in a capital case, he must provide notice to the prosecution at a time set by the court. The court, upon motion by the government, may order the defendant to be examined pursuant to procedures set by the court. Most significantly, the results of an examination of the defendant ordered by the court must be sealed and must not be disclosed to any attorney for the government or the defendant unless the defendant is found guilty of one or more capital crimes and the defendant confirms an intent to offer during sentencing proceedings expert evidence on mental condition. Fed. Akrim. P. 12.2, C. 2. 24. If a defendant facing charges in both state court and federal court is required to raise potential mental health defenses in his state court trial, as the people are demanding at this stage, the federal prosecutors will gain access to the mental health evaluations conducted by the defense and prosecution experts well before they would otherwise be entitled to such evaluations pursuant to Rule 12.2. Accordingly, if Mr. Mangione's state case proceeds to trial before his federal capital trial, he may be forced to choose between violations of his constitutional rights in order to present a complete defense. If he chooses to raise a defense based on extreme emotional disturbance or capacity in his state trial, that choice will cause him to forfeit his Fifth Amendment privilege in his capital trial, along with the protections afforded capital defendants by Rule 12.2. On the other hand, if chooses to preserve his Fifth Amendment and Rule 12.2 rights in the federal trial, he will, by necessity, forfeit his right to present mental health defenses that might otherwise be available in the state trial, because asserting those defenses will require him to undergo an evaluation that will be shared with federal prosecutors. 25. Forcing the defendant to choose between asserting a potential defense in the state court and giving the prosecution in his capital trial an unfair advantage presents the defense with an untenable choice, with possibly fatal implications. Moreover, forcing the defendant and his counsel to make such a choice before completion of the mitigation investigation would require them to make a potentially life and death decision without all the information that they need to make a reasoned decision, thus violating Mr. Mangone's Sixth Amendment right to the effective assistance of counsel. This court should not jeopardize Mr. Mangone's life in that fashion just for the sake of upholding the state's interest in prosecuting him. Rather, it is respectfully submitted that this court should allow trial of the federal capital case to proceed before the state trial. By doing so, the court would be protecting Mr. Mangone's Fifth and Sixth Amendment rights and would enable him to fight for his life with all of the constitutional and procedural rights afforded him by law. Dated, New York, NY June 16, 2025.
Hi, it's voiceover me. So you probably noticed I did not cover the last 2 pages of the 26-page document. The last 2 pages aren't like really relevant or important to Luigi's case. It's just the actual experience and what the person actually does. Now, you can go read those 2 pages if you want to. And I do want to say, at some point in this part, if you hear a cat meow in the background, I'm sorry about that. I am currently pet sitting for someone and their cat wanted to say hi when I was recording that bit. So, and I was already like halfway through the document and it was a really big file, so sorry about that. Anyway, back to the video. So basically this is like the first part of the document where they discuss this is more of them adding to the pre-trial motion that Karen Okafillo written a month ago for Luigi Mangione's case, where they basically bring up Luigi Mangione's rights is being violated again. I don't know how many times Luigi Mangione's rights have been violated in this case. It's like so many times at this point. And they very much bring up the reason why his rights have been violated again is literally because the prosecutors and police released the alleged journal entries from Luigi Mangione to the public. And further along in the document, we will see the reasons why they did this, and it's like very interesting. I just want to bring this up here. I just found this part very fascinating, and like I just opened the document at this point. It's like, ooh, interesting. They did bring up in the document because they want to suppress evidence, because all the evidence they found on Luigi Mangione they found illegally, because again, they did not have a search warrant. Go check out my last video about it, and they very much talked about that. And basically then once the motion to suppress the evidence against Luigi Mangione was officially filed, that's when the police and prosecutors released the alleged manifesto to the public. Like, it's very much giving off, oh shit, we need to release this right now so we can have the public on our side, making Luigi Mangione look like a bad, horrible person before this evidence gets suppressed, before it actually got suppressed and no one can see it. That's what the feeling I'm getting about it. I should probably say allegedly at the end of that sentence, but I do very much feel like that's what's going on and like why they released the manifesto when they did. It's very interesting. They also bring up the prosecutors fail to find any evidence or anything, even with the evidence they actually have against Luigi Mangione. They don't have anything proving for Luigi Mangione to have the terrorist charges put on him, because literally they're breaking their own law so they can basically lock up Luigi Mangione or send him the death penalty as soon as possible so they can get this over and done with. I feel like the reason why they're doing this is trying to make this go as fast as possible and cut corners and ignore their own fucking laws so they can lock up Luigi Mangione so they can make a point out of him. And I do think it's a little bit have to do with, sadly, about politics in the United States at the moment with Donald Trump. And I don't want to be political, but I do feel like that's the reason why they want to do this as soon as possible, so they can make a statement and then move on with their lives instead of actually doing their jobs properly. They also bring up in the document where the prosecutor said Luigi Mangione wants to change the American healthcare system and stop it forever. That was all made up by the prosecution, and also literally everything the prosecutors said at the beginning of the year and probably still now, they very much just mirror what is actually said in the alleged manifesto from police instead of like proving actual points. And I don't think that's a very good way to do your job if you're just echoing what you saw in a alleged manifesto. So I'm glad this was very much brought up in the actual document. So basically the prosecutors, they released documents, a lot of Luigi Mangione's personal information, and released it to the public, like Luigi Mangione's personal identity number. I think that's what they're called. We have it called something different here in Australia. And also in the same document, it had Luigi Mangione's personal phone number, where they had Luigi Mangione's full previous address, where they mention people that used to live with Luigi Mangione probably still live there, and that could be a danger to them. So, hi, voiceover me. I also forgot to mention this. I was reading over the document. They also have his full driver's license number in the document as well. And they also did acknowledge mistakes do happen, but in this case, just because of like how high profile it is, they need to use common sense, because literally that's a lot of personal information on Luigi Mangione's life that a lot of people should not need to know about. So I'm really glad that was like brought up in the documents. They also bring up literally the death penalty put on Luigi Mangione was done way too quickly for it to be actually legal and legit, because putting the death penalty on someone takes years, like up to like 5 or more years to have a death penalty considered to be put on someone, because the amount of times they need to interview people like friends, families, teachers, etc., extended family members, and that was all not done for Luigi Mangione's case. It was just announced on an Instagram post by a judge, basically planting the death penalty on Luigi Mangione without doing any of those steps. And they also explained in the document where the prosecutors, they want this case done as quickly as possible. The reason they are rushing things, they want to do this as quickly as possible so they can send Luigi Mangione the death penalty or put him into prison forever, and they want to rush things and get this done soon as possible. Because again, like I said before, I do feel like it's because they want to prove a point, and sadly I do feel like it's because of a little bit of Donald Trump's influence of wanting to do something about it. When you rush cases like this, you will skip over things, you'll make mistakes, and things won't be done right. And the prosecutors want to do this as quickly as possible so they can make a point out of Luigi Mangione of saying, oh, this is what we do with people who kill big CEOs. I feel like they want to do this as quickly as possible so they can still have that mindset of the people on their side thinking Luigi Mangione is a bad, horrible person, where they can still have those people on their side and they think they've made the right decision. And basically the government is trying to break their own rules that were placed there way before those people were put in office, so they can make a statement out of Luigi Mangione instead of actually giving him a fair trial and actually doing their jobs correctly, if that makes sense. Because they also bring up in the document they want to get rid of the Pennsylvania case, because again, double jeopardy. He's getting charged for the same thing twice in 2 different areas. Luigi Mangione's rights have been violated again, and basically the prosecutors say, why can't they both happen? Why can't Luigi Mangione just use his legal fund to hire a attorney to do that Pennsylvania case? And they brought up, it's very interesting, the prosecutors, they brought up Luigi Mangione's legal fund like twice. It's a bit suspicious. It's like, why do you care about his legal fund? They're not paying you. A bit sus. But they did bring that up, saying, oh, he can hire a attorney to do the Pennsylvania stuff. And they argue in the document Luigi Mangione needs to be there in person to see things, look at evidence and all that in person if he wants to tackle the Pennsylvania case. And then they also argue, oh, he can do it all virtually. And in the document they argued, and even other documents we've seen in the past, where Karen Arcafillo argues Luigi Mangione wants to be there in person every single court appearance and not do it just online, and he has the right to do that. So and having the prosecutors trying to push that to make this as quickly as possible is very sus. It's like, why are you trying to speed this up compared to other cases in the past? And I will touch base on this later on in the video that I literally just discovered last night, like before I went to bed. Again, I will talk about that at the end of the video when we get to that point. But it's very sus what the hell they're trying to do. It's like, why are they trying to rush this as fast as possible? Are they trying to rush this before they have evidence shut down because they found it illegally? Is it because there's going to be more holes showing in the future that how much they fucked up? Like, what are you guys doing? And noting this, I'm just a normal everyday person. I'm not a lawyer, I'm not a person who works in law enforcement, and I can see how much the legal system in this case have fucked up this entire thing, and I'm only reading legal documents. And this is my final thoughts on the full document we just read. So basically, the prosecutors and the government, government is bluntly ignoring its own rules and laws, so they can just basically lock up and kill Luigi Mangione and get this over and done with as soon as possible. And those laws were put in place way before those people were put in office. Like, I don't know the exact dates because I don't know American history enough about it. We don't get taught that here. But it was put in place so shit like this does not happen. But they're bluntly ignoring those rules so they can do whatever. And it's very scary seeing it right now. Especially like seeing in America right now. And if they rush this, there's going to be things that are going to get wrong and make mistakes that we've seen already by them rushing this case. But seriously, why are they trying to break their own laws to make a point out of Luigi Mangione when literally there's so many holes and shit they're fucking up already? Maybe it's because they realize all the evidence is going to be suppressed and they need to get something done quickly so they can have an idea and maybe have something against Luigi Mangione. 24th of June 2025, like literally today. Like this was at I think this was around 12:40 something. I was literally about to go to bed. I was like looking at houses that I dream I want to own one day that I obviously can't afford. Anyway, we're moving on from my weird pastime I do sometimes. Anyway, I literally just saw that and it's like, quick, write this down right now before you go to bed. So, but also take it with a little bit of grain of skepticism because this is literally from Reddit. I couldn't find the official document in person. I did look. So basically this is the prosecutors trying to push Luigi Mangione to do court appearances virtually instead of in person like he requested and he still very much wants to do, that we mentioned before in the reply, where Karen Arcafillo will not let that happen because Luigi Mangione requests to be there in person in all of his court appearances. But this is the prosecutors pushing and requesting for that not to happen. Again, they want to speed this trial up, get this done as quick as possible, and it's like, why are you doing this? But I do feel like Karen Arcafillo won't let that happen and let Luigi Mangione be there in person for all of his court appearances like he deserves. So I'll put it up on the screen for you guys.
Of June 2025, notice of defendant's unavailability for appearance in county court, Cosent to remote appearance Dickey. Thomas M. The 23rd of June 2025, e-service served Blair County District Attorney's Office.
But again, literally, like, take that document with a grain of skepticism, because again, it is from Reddit. So, and I did literally try to find the full official document of that one, could not find it. So again, take it with a little bit of skepticism. It's very interesting to think about. It's like, why do they want to speed this up so much? Is it because they know things are not heading in their direction because what's happening and evidence might be suppressed, and then they won't have anything to go off if that does get suppressed? I don't know. That's what I think. Allegedly, please don't sue me, but I feel like that is why they want to speed this up as soon as possible. This is currently all the information we currently have as today, as filming this on the Luigi Mangione case. Today is the 24th of June 2025 as filming this video. So that is all the current information we have on the Luigi Mangione case so far. So now we are going to be moving on to my thoughts and opinion going on with the Luigi Mangione case, with all the updates and everything that's going on with the case. I do this in all my videos, so I'm going to chat about that now. Bloop. And I'm also going to bring up some things that are not really relevant to the case, but I just want to bring up anyway because I think they're sweet. Or I just want to bring them up anyway, that I thought they were interesting or sweet as well, but they weren't really relevant to the case. The thing I found quite sweet actually from Luigi Mangione, but I think this is sweet. So some people have posted online where Luigi Mangione was, when people were wishing him happy birthday, some people receive letters back from him that they posted online, and basically it was a list of 27 things Luigi Mangione was thankful for, and it was actually really sweet. Some bits made me laugh, some bits made me smile. It was really sweet. I do recommend to go read it. I'll put it up on screen for you guys. Also, one thing I do want to add here, I did look this up, so in the actual list, it does say Latinos for Mangione. I looked that up. It's not actually Luigi saying he likes Latinos. Maybe he does, I don't know, I'm not him. His preference in women is none of my fucking business. It's actually a Instagram fan account. I think that's one of them Luigi Mangione knows about. Maybe Karen Ocafillo or one of his legal team told him about it. But it is one of the really popular fan accounts. So yeah, I just kind of want to clear that up. I do recommend to go read the 27 things he is grateful. It is a very sweet list, and it will make you laugh, it will make you chuckle. I recommend to go read it. I also came across this on Reddit where basically someone created a website where they have all the accurate and correct information for the Luigi Mangione case, and I find it a very useful tool. I literally just came across it. I think I might go in there time to time to get more accurate information for what's happening for this case. So I'll put that website, so if you guys want to gather more accurate information on the Luigi Mangione case that isn't just me, so I do recommend to go check that out. That will be on the website as well. I think it's going to be a very useful tool going forward when I make these videos and getting information in general on this case. So I came across this and I found it very interesting. It kind of is relating to Luigi Mangione's case, but then also not at the same time, but it's very fascinating. There's a lot of information and contacts to different attorneys from overseas, in person, for literally trying to get rid of the death penalty in the United States. It's a very, very interesting read. I do recommend to go check it out. Again, it's the skepticism, but it does seem very legit and serious, and I always recommend doing your own research, but I do find it very, very interesting, and I will put it up on this week's episode on the website, basically trying to get rid of the death penalty in the United States, and it's very interesting. I do recommend it. There's a lot of stuff there that's very interesting to read, so I do recommend to go check it out yourselves. And also, talking about the Luigi Mangione subreddit, I said I posted something in. I think I'm going to take a step back from the subreddit because lately, I don't know why, but I'm slowly seeing it's slowly turning into a echo chamber where anyone's idea on anything, and if it doesn't fit a bunch of people's idea on something on Luigi, people just like disagree and yell at you. So I'm just gonna take a step back and just basically just keep an eye in there just for like updates and stuff of like official documents, because again, I live in Australia. I don't get many access to a lot of documents here, so it's very useful on that kind of thing. But yeah, it's slowly turning into like an echo chamber, and I don't really like that. So I'm gonna take a step back from that place. And I think I discussed this with someone on the actual subreddit. Someone did say, with things like this, an echo chamber was gonna happen eventually, and honestly, just don't think about it too hard and just take a step back. So I'm gonna take that person's advice to heart, so I am gonna take a step back from the subreddit. It kinda sucks, because it was a good place to like discuss about things, what's going on in the case and stuff, and it was very interesting, but now it's just turning into a echo chamber where if anyone's idea is not exactly what people think, they just yell at you. So I am going to take a step back from the subreddit, but I'm still going to be there just so I can get, again, updates and documents for you guys if I can't find them myself. So here's my final thoughts of what everything's going on, not just in general with the Luigi Mangione case, but like with the internet as well at the moment about the Luigi Mangione case. So basically, with the information that's been given to us by the Luigi Mangione case, there hasn't been that much information. Luigi Mangione's case for a month. People are getting restless. They want to know more what the hell's going on with Luigi Mangione case. And sadly, a lot of people at the moment, they're literally taking any piece of information on Luigi Mangione at face value and fact, instead of actually doing any practical research or anything like that on Luigi Mangione's case if the information they're getting is serious and legit, instead of just taking it at face value. But sadly, people can't be bothered, and everyone on the internet, I think currently at the moment, is a little bit thirsty for Luigi Mangione, so they're basically taking anything that anyone says about Luigi Mangione at the moment at face value, and literally like anything they hear, they just run with it. And if anyone says otherwise, they kind of get yelled at saying, no, this is legit and not fake whatsoever, when literally it could be just a lie for clout. I do recommend always do your own research, look deeper into things instead of taking things at face value, because I get it, you want more Luigi, but there is no Luigi. Just calm down, sit back, it's okay? Don't take things at face value, okay? Do more research into things. Again, because I think everyone's just wanting more information on Luigi Mangione at the moment. They take anything about what anyone says about Luigi Mangione and run with it, instead of actually doing any fact checking or anything like that. And I see that with the news as well. They do that as well. And I do very much think, especially with this case, when there's times where there isn't much information coming out, and then when people say something about him and then run with it instead of fact checking about the information and sources, and then people just run with that, and that leads to misinformation. And I think we need to keep the facts straight for this case, instead of letting the media and anything anyone says online about Luigi Mangione and just taking that as fact, instead of actually looking at the actual facts of what's going on with Luigi Mangione's case. We need to keep the facts straight, what's going on with this case, and understand what the hell's going on, instead of running with whatever piece of information we get on this case and Luigi Mangione in general. And I do feel like we need to keep talking about Luigi Mangione, so the facts and all that don't get lost on the internet or anything like that, because he is a real human being instead of a pawn in the government prosecutors game of whatever the hell they're trying to prove. He is a real human being. He is someone's son. He is someone's sibling. I don't know his family dynamic. Again, I do not focus whatsoever or look into Luigi Mangione's personal life, even if it's plastered all over the internet. I very much try to stay away from that part of Luigi Mangione's life. This is strictly just about the case. Again, I'm trying to keep his personal life private as much as possible, even if it is plastered everywhere. I am at least trying to be one person who is respecting that. So, he is a real human being. So I think we all just need to remember he is a real human being dealing with this very scary, stressful thing going on in his life. And we also, I think we need to not put things on him where he can't defend himself online. And I do love Luigi Mangione's legal team, where they made an actual website. They put all the official documents, what's actually going on with his case, so us, the public, can actually look at it and see what the hell is going on, instead of like us just going, what's going on? Why is the news not giving us actual information like it's meant to? So I do really enjoy that, so I'm glad they are also helping with trying to get the actual facts straight, what's going on with Luigi Mangione's case. So thank you, Luigi Mangione's team, for doing that. I very much appreciate it, and all of his supporters out there too. And I do find it very interesting how much the prosecutors are trying to make this done as quickly as possible. Like, it's very much happening now. I feel like ever since the evidence to be suppressed, I think that might actually happen, and I feel like they might be freaking out, going, oh my god, if this gets suppressed, we will have nothing. Shit. Make this done as soon as possible when we still have the stuff, when we can do it. I kind of feel like that's what's going on, and I think they're just freaking out and like trying to get something as soon as possible instead of actually doing their jobs correctly. So I think I'm going to end off this video with, sorry I don't really have any quotes that I like to find and put here. Sometimes I do, sometimes I don't. I don't have any for this, I'm sorry. Again, the subreddit's getting scary. I did mention this in my last video, but I am going to mention this here. So I am not going to stop talking about Luigi Mangione. I'm not going to stop giving you guys the actual documents and facts of what's actually going on with Luigi Mangione's case, because that's why I always show you guys the actual documents and I share my actual opinion afterwards, so you guys get an actual idea of what the hell is going on with Luigi Mangione's case and the actual facts, instead of whatever's floating around and what's popular at the time. So we need to keep talking about him. We need to make sure information on him does not get lost or muddled up or twisted for some agenda. We need to get the facts straight of what's going on with Luigi Mangione's case, so it keeps being alive and people know what the hell's going on with his case and what's going on with Luigi Mangione. And keep supporting him, keep talking about him, keep sending him letters. I'm pretty sure he appreciates them, and I think that's really sweet. Even if he doesn't reply back to you, he gets a lot. I think he gets about 50 to like 115 letters a day. He gets a lot, okay? Keep sharing the facts straight on Luigi Mangione's case. But yeah, I will only stop talking about Luigi Mangione when he requests it, or his legal team requests it. That will be the only time I will stop talking about the facts and what the hell's going on with Luigi Mangione's case. But I will come back in the next couple of weeks when we have more information on Luigi Mangione's case and give you guys updates, unless there's something like really big, and then I'll come back and I'll make a video about it here. So I think that's a good thing to leave off this video with. But yeah, thank you for watching this week's video. I hope you guys enjoyed it. I hope you guys learned a lot. Even if there wasn't much on Luigi Mangione, there has been video I upload every week, sometimes 3 times a month, depends what I'm working on. And if you guys want to keep up to date of the channel and what I'm working on and all that, you can follow the channel's social medias. That'll be down below. That's where I update little updates of what I'm working on and all that. And if you guys want to follow me personally, all my social medias are down below as well. And everything I talk about and all the sources and all that will be on the website on this week's episode. I basically just have it there, so basically it's all in one neat little area for you guys. I should probably mention mention this more often, but if you guys just want to listen along, I do have a podcast version of these full videos, so you don't have to keep watching the videos. I should probably mention that more often, but I don't. I'm bad at advertising. Why do you think my YouTube channels aren't that popular? I'm not good at advertising. Anyway, thank you for watching this week's video. Bye!